Item number 15.
15.
Password for the day lordship. Fixed after petition lordship.
The transfer petition.
Yes,
You are for the
I
petition.
am for the petition.
Have you taken steps for the other side? No.
Already steps completed.
Completed.
Yes.
No, name of other
Yes, name has not
other side
reflected.
is not reflected.
Yes, but settlement is going on. Maybe next day we will withdraw this matter.
At the request of the landlord for the petition, matter is adjourned. After 2 weeks or after vacation, we'll put
After vacation lordship.
list accordingly after vacation. We're gonna get list.
There is an interim lordship pending.
Interim was there. What kind of interim transfer petition?
In lower court, this matter stay lordship. Till the disposal of
It's
this.
the only transfer petition and matter has already been stayed. Anyway, interim be continued till next day. This transfer petition.
Your Lordship, I beg to mention item 34. I appear on behalf of the petitioner, Your Lordship, and we have to seek instructions from our client. We may want to withdraw this review petition. So the matter may be listed up.
One I was also there. That is for condemnation or what?
Yes, Your Lordship, but the review petition has not been numbered yet and no one has appeared till now, and this has been listed for the first time.
No, I'm not on that. One I is there. I
Yes.
is for most probably
For
condemnation.
modification of the order, Your Lordship.
Modification.
Modification.
But why filing number is not yet given?
So, Your Lordship,
Filing number is not there. I mean,
But
it
in
is
the
only
IA
the filing number, registration number is not.
review petition has not been numbered.
So you are for the petition.
Yes, Your Lordship.
You are paying for whom?
On behalf of R.K. Bhatra,
You are Miss
A. Biani.
A.
Biani.
Pardon, Miss A. Biani, Mr. R.K. Bhatra. And the Bitcoin adjournments. Is there any talk of you want to withdraw this one?
Yes, Your
Maybe.
Lordship, they might want to withdraw, so we have to seek clarification from our client.
Second that some clarification is required. Matter is adjourned. Is the matter after vacation?
After vacation.
Yes.
Much obliged, Your Lordship.
May I please, Your Lordship, return to item number 5, madam.
Item number 5. Yes.
Kindly adjourn for that, madam. Listening of the vacation ballot on behalf of
This is
BKD.
the one interlocutory is there, no?
Yes.
It's a matter.
Yes, madam.
So you are for the
I am for the petitioner, madam.
petitioner appellate.
Yes, madam. On behalf of
Have you
BKD.
taken the consent of the other side? Have you talked with the other side?
I think, my lord, BKD can consent to other side, my lord. On behalf
So
of,
these are the items which have been identified
On
for
behalf of-
mediation.
I can mention on behalf of BKD, madam.
Huh?
On behalf of BKD.
BKDS, no, it's
Yes.
okay. But these are the matters which have been identified for sending to mediation, in fact.
He have some medical difficulty and medical emergency, my lord. He's on medical, madam. That's why.
Other side is Mr. A. Kakote's name is there.
Okay, I can consent.
Just make a clarification, Mr. Kakote is there or not.
Okay.
Okay, because these are the matters identified for mediation. There's a special drive in mediation, that's why I'm asking.
Okay.
Otherwise also it's a matter.
Hello, please.
It's just for timing I am keeping, you just make
Okay.
me.
My lord, first I would like to call for the CD, my lord. It was rejected once, my lord.
Okay. And earlier it was rejected?
Yes.
Okay.
Is it
15.
15, my lord? Is a
Yes,
principle, my lord. There is some misunderstanding. Anyway, I'll explain, my lord. On the 15, my lord, for the CD.
Okay. 15th of September. Sit.
Diploma.
You are assisted by
AU1.
AU. Mr. K. Chaudhary, the senior advocate, assisted by Mr. AU. Also, Mr. B. Sharma, 59. Okay, well listed.
Repeat your lordship.
Yes,
Lordship, this case
want
is
it, this
not fit for mediation, lordship.
not fit for.
Lordship. Because there is a violation of policy condition, lordship. So matter may be finally heard, lordship.
And your lordship, I have also preferred one cross objection. In that case, also the insurance company will never enhance the amount in their own. Your lordship may be pleased to fix it after vacation. Maybe on to
You are Mr.
R. Sharma.
R. Sharma, Mr. R. Sharma. Must for Mr. SK Goswami, or your name is not there, that's why I'm-
Appearing on behalf of SK Goswami. lordship.
S. R. Sharma appearing on behalf of Mr. SK Goswami and also heard Mr. D. Mondal, the learned counsel for the respondent number 1. The learned counsel for both the parties have jointly submitted that the matter, there's no chance of any these mediation. There is no chance of for any mediation before there is no chance of any compromise or mediation before between the parties, and that's why it is prayed that matter may be heard and decided in the court itself. Accordingly, prayed when you want to submit it.
your lordship, it can be fixed on 4th of November
After vacation,
after vacation. 4th
Lordship.
4th of November. Then it will be on the
hearing day.
hearing day.
Yes.
I mean, on hearing column or admission
Hearing
column. or-
column.
Hearing,
Hearing.
hearing.
Hearing column. 4th of November, no, hearing column. Yes, you are for respondent.
I am for
You are
1 to
the
7.
same view.
No date.
Okay, you are appearing for respondent number 8. Okay, we'll mention here. 8 only, okay.
Oblige, lordship.
Oblige, your lordship.
Lordship, this is not fit for settlement, Lordship, compromise. Since Lordship, it's a, two vehicles are there, but entire materials and record and
Then
the
if it is not
claimants.
fit for suppose mediation, do you think that it is fit for local adult any settlement? will be
No,
there
Lordship,
possible?
because we are illegally awarded 50%, Lordship. Because the entire materials and record and the case of the claimant is that our vehicle is not involved. Entire FIR charge sheet is against the other vehicle. In spite of that, Lordship, 50% was awarded to us. That is our case, Lordship. Therefore, Lordship, no, while staying, no amount was being granted, Lordship. It may be hard, Lordship.
We are also not
your
ready
case
for
also-
settlement.
Pardon?
We are also not ready for settlement.
Not agree person. You are appearing for who? A
I'm
respondent
appealing
number?
for respondent number 1.
For respondent number 1.
Claimant, I think. Claimant.
4. RMS M. Chaudhary, the learned counsel for the appellant. And also heard your good name,
A Brahma.
M?
A Brahma.
A. Brahma appearing for the respondent number 1 and MS. A. Bora appearing for the respondent number 4. The learned counsel for both the parties have jointly submitted that the case is not fit for mediation and parties are not interested to settle the matter in the mediation. As there are some law points involved, which is to be decided finally. So this matter was also for hearing column was there or did there addition?
I think, Lordship, it is for order. It
Order.
was fixed for order because service is not yet completed.
Services not
Not complete. I think, Lordship.
there is.
It may come up for
Directed to this matter in the order column after vacation,
Lordship.
after vacation and then a date to it's.
Must oblige, Lordship.
Must-
Next is Lordship, item number 4. He is appearing for that.
Item number 4, you are appearing.
I am for the appeal.
They have filed the appeal, Lordship, by the claimant. Item number 4. In this case,
No,
I
no,
am appealing.
the appeal is by the company, so you are,
Yes,
And item number 4 is the another appeal filed by you.
Filed by the claimant.
Arising out of same accident. Claimant has filed.
Claim.
So where is it condonation of delay, Lord?
Lordship,
So
in this case,
Matter
I am
was,
appealing.
these matters were identified for, in fact, mediation. Yes, so when it will be reached at order quorum, then it will be heard.
Yes. Okay, Lord.
Otherwise, if it is, there is a not condonation, then whether there is any order for issuing notice and all?
Yes.
Yes, Lordship. We have received,
Was there?
we have received the notice, but it is
But
not yet heard. Lord.
Not yet, not yet heard or the
Not yet.
station number is not there.
Yes, yes.
Okay. 4 to
One
5
in
to
India,
Belekpuri দিব, 4 to Belekpuri.
In India, food.
To M. Brahmo for the appendage. So far, M. Choudhury for the response. It is submitted by Mr. Brahmo that the condonation petition is still pending for disposal. Matter may be heard in April of this matter accordingly, along with the MAC.
Yes, yes, yes.
Along with the MAC appeal number 108 of 2019. Next application.
And in this case, I'm appearing for respond number 5.
And I'm respondent number 4.
Three.
M. Choudhury is for respondent number 5.
5, Lordship.
And you were Bora for
And respondent number 3.
Agora accepted.
Must
That's
reply.
a pleasure.
Yes, 5 to mark.
I can take.
So you are for the respondent.
Yes, yes, Lord.
Now, this is the matter, so our best effort will be is to be, before the mediation, we want to send it before mediation.
Yes, Lord.
So this they most probably he has some problem,
Yes, Lord.
health issues and all. What about your,
Even my
Yes.
senior, I'm appearing on behalf of Mr. A. Kagoti Lordship. And Lordship, my senior Ekade, his relative have died last night, Lordship, and he went to Tezpur today to visit his relative house, Lordship. I seek for an adjournment, Lordship.
no, adjournment is okay, but we want to send it for mediation. That's what I'm asking. Is there any problem?
Lordship, I need
There
to
is
ask my
one thing.
senior.
You talk to your clients because it is a May appeal. On the next date of listing, just let us know
Yes.
what is the position. If the parties are interested, we'll call for the party and we'll send it for evaluation.
Kindly list
You
up
are
the
Mr.
petition, my lord.
You are Mr.
AK Das, my lord.
Huh?
AK Das, my lord.
You are Mr.
My name is not Ukaldama.
Your good name, what is your name?
AK Das, my lord.
AK Das. You are appearing for BK Das.
AK Das.
Right, so and you are appearing for AK.
A.
A.
Kakoti,
Kakoti. Your name?
J. Pegu Lordship.
JPEG.
Pegu.
JPEG appearing on behalf of Mr. A. Kakoti. Both the parties jointly submitted that there are some difficulties on their part to proceed with the hearing today. That effort. It is submitted that they will take instructions from their client as to whether the parties are interested to settle the matter before mediation. After Puja vacation?
Yes.
Yes. Is the matter according to Apple. Was there any interim? No.
No.
Interim, was there any?
No.
Puja.
Oblast.
Talukdar, you are for the
Yes, no.
respondent.
That's one.
What is for I for? I is for.
I appeal for substitution of legal heirs. Respondent number 1 expired, Lordship. Lordship, kindly see the conduct of the insurance company. Last orders.
May I please Lordship. In this case, Mr. A. Ahmed, he is no more. No? Appellant?
Mr.
A. Ahmed is the appellant advocate. So he is already expired last 5 years back. So I think nobody is interested in these cases. That is why.
Lordship,
On the
kindly see
last
the orders.
provision, last date that is on 23rd of May. When MS L. Sharma was appearing.
Lordship. Earlier may.
He was
Lordship may
also
see-
panel lawyer.
Lordship may see the earlier orders also.
Who is Ajay Saikya? He was also appearing.
Maybe
For
he's
Mr.
appearing.
KK Bhatt.
But not informing properly the company. Since the original advocate is expired. So So today I will inform. If somebody is deputed.
No, United India, you are also,
Yes, yes.
you are the panel lawyer.
Yes, sir. I will inform my lord, I will make it clear. Next day, another, after 2 days.
Let me inform then instruct them, because otherwise if it is unrepresented, your case.
Claimants are suffering, Lordship. And
Yes, you are
moreover, they
suffering.
have
After
not
tomorrow, maybe.
furnished the copy memo of appeal as well as the missed cases,
You have not received.
not received.
So you are for the claimant.
Claimants.
That
Claimants
is
are
also
suffering,
here.
Lordship. This is an old case, Lordship.
2019 matter.
2016, Lordship, MSc case is of 2012,
2012.
Lordship.
My lord, day after tomorrow.
Claimants are suffering. Lordship. 12, 13 years.
None appears in call for the applicant. Heard Mr. M. Collector declining counsel for the petition. However, while hearing the matter, Mr.
RC
R.K. Pal,
Pal.
R.C. Pal has submitted that the engaged counsel for the present case, Mr. A. Ahmed, has expired, and he will inform the insurance company regarding this case as being an panel advocate for the said insurance company. That will be after vacation only, after prior vacation.
Lordship, copies may be furnished,
No, how?
memo of appeal as well as missed cases.
He is not in a position to furnish anything. He's a claim.
I
Once
have to inform, I have to
Father,
submit
okay,
the-
appear,
No, once we, he is just informing the court regarding the
I'll
actual
inform to
position.
him personally.
If the case is entrusted to him, definitely he will be, but yes, I will make a mention here that you have not received. Mr. Telegraph has submitted that till date, they have also not received the memo of appeal as well as copy of the present appeal. Post. But without an engaged counsel, it is not in position to make an order for furnishing the copies to the respondent side. However, considering the submission made by Mr. R.C. Pal, let the matter, if it is before vacation, you want any date?
Lordship,
Before vacation, you want any date? You want any date
yes,
before
yes, before
vacation?
vacation,
60 date maybe,
before vacation, maybe.
the date may be fixed one. So I can apply this code.
Lordship, observation may be made.
Yes,
If
I have already made.
next time they fail to appear, then appeal would be dismissed.
It's kind of now, the person is no more. As Mr.
No,
Pal has submitted, person
subsequently,
is no
so
more.
many advocates appeared and
That is the cost on the part of the company, definitely will try to it, demand for their divorce.
My lord,
16,
six-
16 of this
17
month.
17 of September, 17, Wednesday.
17, we are listing a list numbers of matters.
My lord,
16 maybe
16.
16.
Lordship 16, some other matter has been fixed, Lordship, hearing matter.
only for my
Other day.
information, regarding information.
Only for
17.
information. Okay, then 17.
My lord,
17th, Lordship.
Mr. Pal,
17.
just inform us, inform the
My-
company.
I'll take
So
care.
that case
Lordship,
can be
17th.
proceeded.
My lord.
17.
May I please proceed? In this case, my lord, I file an appeal against the judgment and award because this is a peculiar award. So this cannot be settled. So it required to be heard.
Otherwise, it is in the which column?
My lord, interesting is that initially the filing claim petition. What to 8? 7 and 8. 7. 7. 8. 7.
Ako mapasok ko na yun.
Yes, yes. My lord, initially filed this claim petition by the claimant, 166. They failed to prove because it is 302 case under section. So they failed to prove the ration negligence. Claim petition was rejected. Filed this case, appeal. appeal was remanded back on the basis of the some judgment that is not maintainable. What happened in the case, in the lower court, when it is remanded back, peculiar he come to the finding, assess the quantum on the basis of the WC Act, cannot be. Because there is a provision of MB Act. So we have challenged that quantum. Because
Just a second, initially it was a 302.
Hey, 302.
FIR was
302.
there, but subsequently it has come to, it's not a case of 302,
Yes,
maybe
302.
304A or something.
Because they also tried for 163A initially, before amendment. So 63A also tried for this landed tribunal, then ultimately rejected because there is a no rational negligence. This is a murder case. So ultimately, this case is not maintainable in the MSCP court. So it is only maintainable in the proper court. The WC is maintainable, so far I understand. So it required to be heard,
Otherwise, it was in which column?
my lord.
In hearing column, it was.
Yes, yes, hearing.
Hearing. Okay,
Sir,
Mr.
yes, sir.
Talukder. Now, he
68.
did that point that there is issue of maintainability also is there, which is the law point that has to be decided and heard by this court. Okay. No, we tried to send it for mediation because these are some cases that have already been identified for mediation. But now Mr. Paul is submitting that it may not be a case for mediation. Would you want to submit anything?
My lord, the ball is in the hands of the appellant. If they
Yes.
are agreed for mediation, I have nothing to say. If they are not agreed, then actually this matter is regarding not murder actually. While the vehicle was in
But
motion,
302 is there,
murder
how we
took
can
place
say
by
that not
the
matter?
terrorist. So it is while using and enjoying the vehicle, the murder took place. So let this matter be heard by court.
Yes,
It will be
that is
better.
right.
Yes, there are several observations of the apex court also while in the use of that if murder is there, is person died, then it will come under the test.
But
My
that
lord, the
is,
court has passed the order. Tribunal has passed the order dismissing the appeal, dismissing the
petition.
MSC case, MS claim. Thereafter, the appeal was filed by the appellant. Both the counsels are there. And this appeal was, impugned judgment of the trial court was set aside and remanded the matter to the tribunal.
unnecessary.
Now the tribunal has passed the order. I do not know whether it is correct or not that this matter will be decided by the appellate court. Tribunal has passed the order deciding the WC Act.
Yes.
Deciding the WC, it is admitted fact. So that matter will be decided since the appeal has been filed by the appellate court will decide.
That is why I'm paid, why you
No,
think
that's what he is saying, that it
Yes.
is not a
you're
case
wasting the
for
time
mediation.
unnecessary.
Because there are
From the
some
last
non-
home, so many days, this case was fixed for hearing, but one after another date, it was.
I am not taking date.
So let this matter be fixed.
You are
for
choosing
hearing.
some particular
No date made.
court.
From last 2006 to till today, the parties are suffering.
The party suffering, you file in the wrong forum. That is, you people are suffer your client. You file in the wrong forum. You are the best judge to where you are to file the case. You file the instead of WC case, you file
So
an
why
MSCT
you
court.
file your I is for?
My IA is for vacation of the stay, my lord.
No, already staged.
Stays there. already?
Yes, my lord. That is why interim order shall.
So that I am not pursuing this IA now. I have the order is
Would do.
there. I am not pursuing this here matter may be heard.
My lord, in the meantime,
Okay,
state may
Mr.
continue.
Had Mr. R.C. Paul did the net counsel for the appellant and also had Mr. Haidar, counsel for the respondent. It is submitted by Mr. Paul that there are some law points involved in the LS debates and also he raised the issue of maintainability. Accordingly submitted that matter may not be sent for mediation and needs to be heard.
But date may be fixed.
Also take the submission made by London Hospital. Let the matter be
Yeah, that's
listed
fixed
for
for you.
hearing. You want any fixed date here?
My
Or after
date
vacation?
may be fixed for hearing. Hearing
May
column
come under after vacation also.
after vacation.
Before vacation, if it is possible.
Not possible to me also.
Vacation may not be possible.
Me also, I do not know this honorable
May
court.
not be possible.
Immediately after the vacation, my
That's-
lord, 28 October. Huh? 28th October.
28
Interim order pass earlier itself continue.
20. Interim order be continued.
Much. Okay.
May I please be with the Lordship, the condolence of delay petition, 45 days delay. So I have.
No, this case is identified for mediation.
Lordship, first let it be registered, Lordship.
No, suppose the other side is ready.
Lordship,
Then
it
it
is
can
not
be
fit
settled.
case. It is for quantum imputation case, Lordship. So
Huh?
it will require hearing, Lordship.
Amputation.
Right leg, Lordship.
No,
So
right
this-
leg amputation is all right. We
No.
are on quantum only.
No,
Quantum
Lordship,
can be decided before the mediation.
Lordship,
If the other parties reject.
no, Lordship, actually, it is not fit case, Lordship, because it involves much amount of quantum, Lordship. That may not be settled. So first delay may can be condoned and appeal may can be registered and then only.
What do you want to submit?
Lordship, I have not received the copy till now.
I'll give the copy, Lordship.
So it is very difficult for me to submit, Lordship.
No, it is delay condonation.
No, we are not going to dispose because these are the matters for.
If it is on quantum only, then we can. move for
Yes.
mediation.
If you are based on quantum, then it can be.
Because delay can be condoned.
Delay may can be condoned, then after admission, they will fix in the next of the Lordship.
But today we are not going to hear on the delay because these are the case for mediation only. These all the cases are identified for mediation.
But Lordship,
We can give you a date.
the orders are, the condoning delays, general orders are being passed, Lordship.
Heard Mr. A.R. Agarwal, the Learned Counsel for the petition. Oh, sorry, applicant, and also heard applicant of the application, also heard your Mr.
SP Sharma, Lordship, respond number 1.
SP Sharma, I bring for the response number 1. It is submitted to both the parties that the case is yet to be registered as the delay is not yet condoned. Want to hear how many days delay?
45 days only, Lordship.
You are not objecting to it. Okay, then we dispose of the hearing matter. Where is the, you have explained your delay, why
Explain
is
it.
delay?
Para number 3,
3,
page 2 and 3. Para number 3, 5. Page number 2, 3, 4, Lordship.
I-104 oblique. Heard Mr. A.R. the Learned Counsel for the petition, also heard Mr. S.P. Sharma, the Learned Counsel is appearing for the respondent. This is an petition. The case was identified for sending it to mediation. But considering the submission made by the counsel for both sides, it's seen that the matter is not yet registered due to pending petition for condonation of delay. Next part. This is an application, the section 5 of the Limitation Act for condoning the delay of 45 days in preparing the MSC appeal and collected MSC appeal against the impugned judgment and order dated 19/7/2023. Passed by learned member MSCT number 1, Kamrup M. Guwahati in MSC case number 294 of the
Lordship, this is Balpada, Lordship.
Gwalpara.
Yes.
Oh, then you make correction. Make correction. It's the case of Gwalpara.
Yes, Lordship. Lordship, it is mentioned Balpada, Lordship.
Where?
It is a Lordship.
Huh? এইবিলাক চব উল্টা পুল্টা
Motor Accident Claim
Yeah.
Tribunal, Goalpara, in MS case number 294.
এইবিলাক এখন ইয়াতে দিছে চলাইছে যদি নাজানো চাব দিয়ক নহ'লে দহটা চলাই during the deliberation of case it is submitted by Mr. Agarwal that the case is of Goalpara MEC Goalpara MECT Court of Goalpara and accordingly in that case is asked to amend the cost title accordingly. Matter may be listed for amendment of the cost title as on a date within the list.
So you have to amend the.
Yes,
Because-
thank you, amend.
Obliged.
List accordingly, the chairman of court will be. It would equally.
Please, Your Lordship. In this
Yes,
case, I am for the respondent number 1 claimant. This matter is listed on the strength of my mention memo because I have filed the IA for releasing the 50% amount deposited by the insurance company. And it is IA is not take with that. Day after tomorrow, Your Lord.
that after, that apart, these cases are for
Right for
mediation. only.
mediation.
Yes. Yes, Mr. Bhatta, what do you want?
We take people to look at a lot.
Can be.
Look at a lot.
Blake will look at it on 13th.
Yes.
If you want, then we can place it on before 13th. I heard Mr. K.K. Bhatta, the learned counsel for the applicant, and also heard Mr. S. Islam, appearing for the respondent number 1. Considering the submission made by planning counsel for both sides. Let the matter be listed before local alert. To be held on 13th, 9th. Registry will be registry as well as this state legal services operative will be. No, the registry as well as the High Court Legal Services Authority will be dealing. Okay, we are trying to send it.
All right, sir.
Met with Your Lordship.
Hmm.
Delay of 26 days, my lord. The other side has, other
Other
side is,
side is there.
he is appearing, my lord. He is just outside, my lord.
For
Okay.
timing, we'll keep it.
We can wait. My lord.
Eleven is also one I is there.
Yes.
How many
yeah.
days
I have
delay?
for condonation of delay, Lordship. My learned friend is appeared for the claimants.
I don't have any objection, Lordship.
How many days delay it is?
160 days.
160
days.
I don't have any objection, Lordship. Definitely.
Where you have mentioned your delay,
Yes, Lordship. I have on para
grounds
number,
of delay.
on
Para
para number 5 to 8, Lordship.
5 to 8. Because that means because of
There's some procedural delay.
procedural formalities.
Yes, yes. Appeal is against the quantum, Lordship. Since the claimant has no objection, delay may be condoned.
Heard Mr. K.K. Bhatta, the learned counsel for the applicant appellant. And also heard Mr. A. Agarwal, the learned counsel appearing for the respondent number 1 of the case. Next, this case was identified for sending for mediation. However, it is seen that the case is not yet registered due to pendency of and application for condonation of delay of 160 days. Next, it is submitted by Mr. Bhatta that there was no intentional delay on the part of the appellant. However, for observing some procedural formalities, there was 160 days delay in preferring the present application. Mr. Agarwala, the learned counsel for the respondent of the claimant, There is no objection submitted that. There is no objection if the delay is found and appeal is delay is found and appeal is registered. After hearing the submission made by the both sides, I have also paid the petition wherein in para 5, 6, 7, and 8, the delay has been explained. And basically, it seems that due to for observing some procedural formalities, there was a delay in preparing them. So considering this aspect of the case and also for the ends of justice, the delay of 160 days is thereby concluded. The petition is accordingly allowed. Registry will numbered and registered the connected appeal which has been filed against the.
Lordship, my name may kindly be shown in the query list. Look. Next.
Your name is here only.
No, in the admission. While registering the appeal, Lordship, there will be different case, though
Appeal
they are not showing, Lordship.
It will give, which is be filed against the. Judgment and order filed by learned member MSCT number 2 Kamrup M in MSC appeal number MSC case number 211/2019, whereby the petitioner the claimant was awarded with an amount of rupees 22,75,106.30 with 9% interest per. Registry will do the needful in registering and numbering the connected MSC appeal. And it is also requested to the registry that the name of the engaged counsel may be reflected in the copy list. List. I use this.
Wait, please, Your Lordship. My lord, we have filed an compromise petition, Lordship. We have settled, both the parties settled the matter outside the court, Lordship. This is the IA, Lordship. 1689/2025, Lordship. In paragraph 2, Lordship.
So your settled amount is 8,30,000.
Yes, Lordship. Wait, over.
You are for the claimant respondent?
Yes, respondent once.
Response number 1 to, yeah. 1 to 6. 1 to 6.
Down to 9.
One to 6, sir.
One more, it is not yet registered.
No, Lordship, IA is registered. IA was for delay 1267. Now it is, we have filed a compromise petition that is settled, the case is settled at an amount of 8,30,500 outside the court, Lordship. Therefore, both the parties filed this joint compromise petition, Lordship.
In that case, the IA 1267, there's no
It
use.
will not work because after that they have settled. Once it came
What
for
is,
local.
So it will be, I mean, full and final set.
Yes, yes, full and final settlement. Paragraph 2, Lordship.
So what was the earlier awarded amount?
Award is same, Lordship. Only the interest part.
Is waived.
Yes, Lordship. Award is of rupees, Lordship, may kindly find in the award. Award is of 8,30,500 along with interest 6%, Lordship. In the appeal, it will be there, Lordship.
Within what time you want to?
Within, Lordship, we have mentioned here within 45 days from the receipt of the copy of the order, Lordship.
Before registry, you want to deposit the matter or?
Yes, before the registry it will be, no? Before the
It will
registry.
be your convenience. either before AST or before this court? Which one you want to prefer?
তাতে দিব লাগিব before the tribunal. Before the tribunal.
Before tribunal? Which tribunal? is it?
Responding is resident of Halagan, not here. That is the answer. Otherwise, they have to come here.
Tribunal, before the tribunal, lordship, it's a tribunal of
Hailakandi.
Hailakandi.
I said 16895. First item. Heard MS M. Chaudhary did on it counsel appeal for the New India Insurance Company applicant. And also heard Mr.
T-Roy.
T. Roy appearing on behalf of respondent one only claimant is also one only.
Lordship, claimant 1 to 5, lordship, because the father, mother, and the brother and sister, 1 to 6. One,
So you are appearing for all.
yes,
one.
claimants.
So just a second, was there any the quantum was divided, there was any division
No,
of the
lordship,
quantum?
one being the major parents are there, lordship.
No,
As
that
per
is,
judgment, there is their lordship. That is judgment, lordship. In paragraph 19, it is written, lordship, 2 unmarried daughters and 2 minor brothers, and page number 25, page number 25 of appeal memo. To the claimant number 1 to 6, lordship. Page 25, Lord. Type it. Say it. Take owner to driver.
So now you are representing 1 to 6?
Yes,
Are you representing 1 to 6?
all the claimants need to be said.
It's
No, don't make any confusion, just tell her.
actually, you're not, my lord, I have filed local number on the respondent number 1 only. So what is 2, 3, 5, 6 is concerned, I am not letting local number.
Because award is for all, 1 to 6. Do one thing then. We may, in your person to your compromise petition, matter may be referred before the local adult on 13th also.
Yes,
That can be done, then you can take the
but the
instruction.
problem is that in the last occasion, Lord said it was placed before the local adult, but the parents could not come because of some problems. As the council
Sometimes it
said,
happens that if the advocates put his signature and papers, then local, I know there may be difference
Yes,
of
yes,
opinion
yes.
also, sometimes
Yes, yes,
maybe.
lordship.
But if you can, in that case,
Yes,
you can
yes.
take instructions also. Because today we don't have anything before us.
Can be placed before local
Local,
adult.
not 13th. Well,
13, 13.
Okay, hard decision, huh? By the present, the compromise petition has been filed submitting that both the parties have settled the matter amicably outside the court for full and satisfaction amount of rupees.
Apply to claimant,
30,500.
Yeah.
However, the petitioner for the respondent submitted that he needs to take some instructions in regards to take the instruction from his client. In view of this, let the matter be listed before local adult on 13/9, which may be settled. Okay, 13/9.
Must oblige, lordship.
Please bring me, Lord. Lordship, item number 8, Lordship, corrected post title is already in the record, Lordship. So, my land file also here.
Okay, we'll ask the registry to fix at the short date, and then we'll hear that.
But the order will be, it is already a matter of record, Lordship, so
Sorry,
direction issued to me, that will be mistake, Lordship.
whatever, we'll see to it. Iman, Iman. What did you keep going? আচ্ছা 13. Yes, 13. This is also identified for this mediation.
Yes, my lord. But there is delay of 10 days, my lord.
10 days delay.
10 days delay.
Do you have any objection there? No. You are for the respondent number one. There's a claimant.
Yes, Lordship. Lordship, a copy may be served. That will.
No, we are not registering the case, we just dispose of the matter. Heard Mr. T. Kalita, the learned counsel for the applicant, and also heard. You are MS?
R. Shahin.
R. Shahin appearing on behalf of Mr. P. Neo for the respondent number one, the claimant. Full stop. This case was identified for sending it before mediation. However, it is submitted by the learned counsel for the applicant that the case is not yet registered as there's a petition for condonation is still pending, which is filed under Section 5 of the Limitation Act. Read with Section 173 MV Act for condoning delay of 10 days in filing the connected MSC appeal against the judgment and order dated 10/2/2025, passed by learned member MSCT, Biswanath and Biswanath Charigali in MSC case number 37 of the where you have explained your delay.
My lord.
Delay, you have explained your delay in which
My
part?
lord. Yes, my lord. So, my lord, it is para number 3 to 6, my lord. 3 to 6.
3 to 6.
3 to 6.
So basically it's for this observing some formalities with the
My
company.
lord, my lord.
Procedural formalities.
Proceed.
Is submitted by Mr. Kalita that for observation of some official formalities, there was a delay of 16 days, in 10 days in preparing the connected appeal. And appeal. Also, there is no laches or negligence on the part of the applicant appellant in preparing the appeal with 10 days delay. In that context, MS for also raised no objection and submitted that the respondent has no objection if the delay is complete and case is accordingly raised. Next para, hearing the submission made by Rana Council so paid. Case record, and it is seen that the delay is well explained in para number 3, 4, and 5 of the petition, where from it is seen that and the delay, there was a delay of 10 days only for observing some official formalities in preparing the appeal. In view of this, the present I is allowed condoning the delay of 10 days in preparing the connected appeal. Registry will do the needful in registering and numbering the appeal.
Much.
I will dispose.
What input? There is a delay of 26 days. my lord.
Oh, other side of what is it? Have you informed the other side? You are appealing. Achha.
Lordship, we have no objection if the delay is continued.
Pardon?
We have no objection.
Okay. Same order, equal it, same order. How many days delayed? Yes.
26, my lord.
26. The ground is almost same here.
My lord.
also? Procedural.
From Dibrugarh, my lord.
You are MS?
S. Chaudhary.
S?
Chaudhary.
S. Chaudhary, appearing on behalf of?
Respondent number 1 and 2.
This phone number 1 and 4. Your name is
Peter.
not here, that's what I'm asking. Your name is not reflected in the call list.
Lordship 1, 2, and 3.
No, 1, 2, and 3 is okay. Your name is not there.
Yes, your Lordship. Actually, Mr. J. Polita, he is the engaged counsel.
Huh? check করে দেন তার নাম তো লিখিত check করে so you don't have any objection na? Same order huh? Okay DSA also we say add
Much.
May I please your lordship? My lord, this is petition is against rejection of an order by the learned trial court of my prayer. Very simple, very small thing. When I filed the WS as a dependent number 1, the main dependent, my lord, the others are only formalities, as they are the sellers of land to me.
you are representing dependent number 1
One, my lord. My lord, and here as a petitioner.
oh what
My lord, they have challenged the purchase of my plot of land. The plaintiff, my lord, on many grounds, my lord, whatever it may be. We are not on that. After filing, I have filed the WS. After filing WS, it went for ADR, alternative
ADR.
dispute redressal, but it took place in our village instead of court, non-formally. Outside the court, there is a joint sitting of the entire villagers set to settle the matter after WS being filed. While in discussion, it came to light that my southern side owner of my land has 2 plots at the southern side. One plot belongs to one Abdul Mumit, and another part also he has purchased from one of the family members of the plaintiff, larger family member of the plaintiff, but it is not transferred in his name. Since 2009, he is enjoying. We all know that the southern side part of southern side land is purchased and still enjoying by one Abdul Mumit. But in record, we do not know that it was not transferred in his name from the seller because the seller died and it remains so. But to our knowledge, he is enjoying, he has purchased it. So in our purchase deed, my lord, in the southern side, the name of Abdul Mumit is there. Though part of the southern side land is remained in the name of as per record to one of the family members of the plaintiff. Finally, my lord, the map, so that your lordship becomes clear. My lord, in the southern side, kindly see, my lord, two part of land, my lord. There are two part of the southern side. One part, both is owned by Abdul Mumit, but one part is, though he has purchased
name was not
in 2009, my lord, he was not transferred in his name and remained in the plaintiff's larger family members. So I have went for a rectification deed in 2022 after the joint sitting for mutual settlement when I come to know, my lord. Then, my lord, I have filed went for a rectification deed, and it is registered, my lord, as the original deed was, my lord, 651 dated 23/5/2017. My, I purchased the land earlier. And the rectification deed, my lord, I have executed by the owners again by number 628 dated 29/7/22 after filing of WSP. Now I only want that in my WS in the southern boundary only the name of Abdul my lord, the seller should be added, my lord. Abdul Habib or Habibur Rahman should be added with Abdul Mumit, only this much. Otherwise, my lord, after long years of litigation, at the time of execution, regarding boundary, it will be a problem, my lord. And oh, my lord, kindly turn to the impugn order, my lord. page 28.
That for that you had filed any amendment.
Yes, my lord.
For
Yes,
WS,
yes.
that
Yes.
was rejected.
That is the order, impugn order, my lord, kindly see. Dated 15/3/2023, my lord. Both the sides are represented.
Which page?
My lord, page 28, my lord, Annexure B.
Hmm.
My lord, before that, your lordship may go to page 24, my lord. This is, my lord, a petition under section, order 6, rule 17, read with section 151, my lord. Kindly see to the prayer part only, my lord. My lord, page 25, my lord. It is therefore prayed that your honor would be pleased to allow the petition and allow the defendant number 1 to amend the written statement and objection of the miscase in manner as stated in the schedule below of this petition, and your humble defendant number 1 as in shall ever pray. This is the schedule, my lord. That page number 5, para 15, Roman 4, line number 8 of the written statement, after the words deed number 651 dated 23/5/17 and before the words and by delivery, the words and rectification deed number 628 dated so and so to be added. In page number 5, para Roman 4, line so and so, the written objection of the miscase after the words, the same thing. In miscase in the main case. This, my lord. Now, my lord, come to the impugn order, page 28. Your lordship got it, page 28.
So at present, your name has already been mutated over your purchased land or not yet?
My lord?
Your name has already been mutated in over the purchased land, not yet mutated.
No, mutation is not done because the case is pending there, my lord. That's why we have not done for mutation, my lord. Injunction is there, my lord.
Oh, injunction.
Status quo, perhaps, status quo is there.
That apart, lordship, my learned friend is going other way, lordship. Their deed was paid on 23/5/2017, and after filing WS, lordship. Their
Yeah, earlier date was 23.
lordship, the original deed was executed on 23/5/2017. And rectification, sorry.
Yes, what that was on 22.
22. After filing WS, while came to know in the WS there is no such aberrament is there, lordship. It will change the nature and features of the entire suit, lordship.
Okay.
And
Let him submit then.
lordship.
So that is the order.
That is the order, my
Ah.
lord.
That is order passed on 15/3/2023.
Yes, my
Yes.
Page- Lordship, order, impugn order, page 28, lordship.
Yes.
Annexure B. My lord.
My lord, kindly turn to page 54, my lord.
54.
54, my lord. The crux of the issue, my lord. What actually? 54, third line, my lord. From top. Habib Ali and Mahbul Ali, sons of late Hamid Ali, also got the same land within the suit first schedule mentioned land of the plaintiff, where from Mahbul Ali sold and transferred right title, interest and possession of 3 justices of land to Abdul Mumit, which is false to the adjacent south of the purchased land of answering defendant number 1, and by executing registered deed number 1046 dated 14/8/2012, Habib Ali also sold 3 justices of land false on the further south to the said Abdul Mumit from within first schedule land. Said Abdul Mumit, my lord, there are 2 parts I have shown in the map. One part is sent by one brother and another part is sold by another brother to Abdul Mumit. But second brother has died before registering it and transferring it. But Abdul Mumit is enjoying, and we all people knows that in the area, Mumit has purchased it, he is enjoying for since 2009. So nobody knows that it was not registered. When the joint sitting took place, then it came to light through discussion, oh, it is not been registered, it is remained in the original owner's name. And because the plaintiff also belongs to the same family, other family, that's why complication may arise in future. So we have gone for a rectification deed and prayed for correction the WS only this southern part. That much only, this part of the southern part only. My lord, then kindly see, my lord.
My lord, learned friend is
My lord,
continuing his trial lordship here. Only impugn order, page 28 may kindly peruse to save your valuable time of this honorable court, lordship. There is no such infirmity in the impugn order, as because, lordship, they had filed WS. After filing WS, in the meantime, they came for rectification of the boundary and came with this petition of amendment, lordship. This is not due diligence and Lordship, with all fairness, I am respectfully submit, kindly peruse the order, Lordship, page 28. My learned friend is moving this.
I
way.
will be allowed to complete, my lord.
May be complete, but this is not the Lordship. This is suit is pending there by virtue of the stay order of this honorable court, Lordship. Both the parties are suffering, Lordship. My learned friend is moving like a producing the map, everything. This is not the place, Lordship, in the revision, Lordship. He came here challenging the impugn order, page 28.
Yes,
May I kindly
that is the
peruse,
order.
Lordship, and consider that, Lordship, whether that order
As
is.
a whole also, I have understood that he want to submit that in the southern part, there were 2 plots of land. And one was mutated in the name of the registered owner or whatever, but the other ones was not
This
registered.
is also not correct, Lordship, because exact position, Lordship, exact position, I am possessing that side, Lordship. Now, while purchasing, there was nothing. While I came before the learned court below, they filed their WS. In 2017, the deed was made, Lordship, and after filing written statement in 2022, they came with a rectification on 28/7/22, and WS was filed on, Lordship, 3/3/2022. After filing WS, Lordship, which will cause irreparable loss, will, Lordship, there is an entire change in nature of the feature. Kindly read the impugn order, Lordship, page 28. What is there, Lordship? I am not on that against my land, but the normal procedure, Lordship, due diligence is there or not. Amendment, when it is possible, Lordship, after filing WS, and only one, Lordship, respondent, remaining other respondent, they jointly filed written statement. And he came with a one single person, Lordship, that the respondent number 1, defendant number 1, came with a petition for amendment without keeping others, Lordship.
No, the other respondents are pro forma or.
No, they are
They
the
are the
main
main.
respondent. They are, and jointly they filed their written statement. Yes, written statement filed jointly, Lordship. And subsequently, my learned friend client filed a petition for amendment. And that too, Lordship, after filing written statement. And after filing written statement, while they found that their written statement is completely, Lordship, it's a misconcept in law, Lordship, they came with a rectification deed and also filed a petition for amendment. Only one respondent, Lordship, jointly they filed written statement. What about the others? That order may kindly peruse. If the infirmity is there, Lordship, by respectful submission, there is no such infirmity in the impugn order. The learned court will correctly pass the order. I am supporting that, Lordship. Page 28, may kindly peruse. To save your Lordship's time, Lordship, just I am coming because my learned friend is making confusion on that. This is not the place, Lordship. Whether this order is perfect or not. If not, Lordship, then the question, while my learned friend is raising this way, that we are showing the evidence, there is a, Lordship, there is a suit is pending before the learned court below. And there is an injunction, Lordship, not to, and in the meantime, they make an amendment, they make this
For rectification.
rectification deed. How it is? Because stay order is there. And then after that, they came with this petition. The learned court below, may I read this order, Lordship, for your kind consideration, Lordship? Both sides are represented. By this order, I am going to dispose of the petition number so registered in miscase connecting title suit number 411 of 21. In the said petition, the defendant number 1, only defendant number 1, petitioner, has prayed to allow to amend the written statement objection of the miscase by rectifying the deed number so dated as per schedule mentioned in the said petition. The petition was received by the other side with objection. The plaintiff opposite party has filed a written objection. We filed our written objection by number so against the petition number so and so. Defendant number 1 praying for dismissal of the miscase. The opposite party submits that the defendant number 1 petitioner, in the spite of having no source of the title or possession over the LS suit land, with his evil and malafide motive, created LS deed rectification side, deed rectification number so and so of the SR of Bhanga Bajar, knowing the fact that the learned court by order dated 2/6/20 miscase number so and so directed both the parties to maintain status quo as on today. Moreover, the opposite party also submits that on 3/3/2022, the defendant number 1 to 17 jointly submitted their written statement alleging false, baseless, concocted aberrament and allegations. In the said written statement, it is nowhere stated that the southern boundary of the land of LS deed number so and so was wrongly written. In their written statement, they have never mentioned. Heard both sides, perused the amendment petition along with objection petition and connecting title suit. The guiding principles of the amendment under Order 6, Rule 17 is that the all amendment ought to be made for the purpose of determining the real question in controversy between the parties to any proceedings or correcting any defects of or error in any proceedings. In the instant case, in hand, the petitioner seeks to amend, rectify the deed number so and so, whereas in the written statement as filed by the defendant number 1 to 7, it was mentioned registered sale deed number so and so, dated 23/5/2017. After several years, filing of this suit, Lordship, kindly consider the written statement was filed jointly by 1 to 17, whereas the amendment petition is solely filed by the defendant number 1, only one person. On 3/3/2022, it can be seen that the proposed amendment sought by the petitioner would take away the vested right of the plaintiff by setting up a fresh claim, introducing new facts in respect of cause of action, amounts to a different fact, changing the character of the suit. Moreover, the written statement has been filed jointly by defendant number 1 to 7, whereas the amendment petition has been filed solely by the defendant number 1. Hence, cannot be amended at the behest of one when others do not join him. The defendant cannot be allowed to introduce fresh plea in replication contrary to the original plea, as the defendant brought some additional fact which inconsistent with the earlier written statement. Therefore, considering the fact of submissions and for ends of justice, this court deem it fit to reject the prayer of the defendant petitioner, as the proposed amendment sought will simply introduce a new case and in effect virtually change the nature and character of the case. The petition number so and so is disposed of. Miss case is disposed of contest. My respective submission, by virtue of that amendment, Lordship, a fresh case, the present respondent plaintiff will suffer, Lordship. So that amendment, which is rejected by the learned court below, correctly done, Lordship. So my respective submission, Lordship, this petition is not mentally liable to be dismissed, Lordship. To save the time, because there is an stay order, and also stay order from this court, it is pending since, Lordship, 2023 and 2025 for amendment, and that amendment will affect the nature and features of the case, Lordship, because a fresh case will arise if the boundary amendment is allowed. That to be also, because this is not under challenge, they came with a fresh plea. While knowing the above facts, filing in the written statement, they have not stated anything about their boundary, effects of boundary. And 2017, that deed was done. Rectification was done in 2022, Lordship, after filing written statement. And now they came with a plea of various pleas of this and that and drawing pictures and everything village. Lordship, they are my respondent, Lordship, here in plaintiff is the victim of all this unjust harassment. So my submission, this order will remain and this revision petition may be dismissed. With my submission.
May I continue, my lord? My lord, then kind to page 54, my lord. My lord, I was midway stopped by my learned friend, my lord. Probably and mobily, my lord, the third line, my lord. The plaintiff filed the instant suit on totally false, fabricated, baseless statements and allegations. Probably and mobily, sons of late Hamid Ali also got some land with the suit first schedule mentioned land of the plaintiff wherefrom Mogulali sold and transferred right, title, interest, and possession of 3 justice of land to Abdul Mumit, which falls to the adjacent south of the purchased land, answering
No,
dependent
that,
of
these are
number
the
one.
entire facts of the case. We are not
Yes,
going
my lord.
there by the entire facts of the
Yes.
case or not. The suit is not before us. Only-
Number one. Number
Only
two.
you are for the revision, so that's why whether this order is any defective or any improper or any.
Yes, my lord, coming to that.
illegalities
What my
involved.
learned friend has said, my lord, why the only one is come. The other 17 are the seller of the land to me. They are only just made the parties for though not made pro forma by them, but they are the just formalities only. And the rectification deed is executed by all of 17 of them. What happened, my lord? All the 47 respondents in the case are the member of a larger family except me, larger family, and they are now for 13 generations residing in different districts of Assam, some with business, with job, and my lord, 13 generations they are residing in different.
But all the 17 defendants have jointly filed.
Yes,
the
jointly,
objection.
no, my lord, jointly filed the WS in favor of me. And when the rectification issue came, they all jointly signed and executed the rectification deed also. The 17, all 17%. Only because I am the sufferer, I am the victim before we get to the case, because I purchased land in 2017. So I thought that by filing by myself it will be enough, my lord. They are the seller only. My lord, they have executed the rectification deed also, my lord, by all the 17s, my lord. I have the copy, my lord. Now, my lord. And my lord, by changing the same, no changes, my lord, nature and feature is going to be changed, my lord. My lord, in this regard, my lord, kindly, there should be due diligence. I have clearly said that till that it is enjoyed and possessed by Abdul Mumit, only the land is not transferred from because of death of that person earlier in 2009. And I have purchased in 2017, after around 9 years. This part, my lord. No substantial change in my WS, only just part of the southern part, my lord. The boundary description schedule, my lord. I had no knowledge before filing the WS. I clearly mentioned, my lord. My lord, it is necessary, my lord. It is not necessary, my lord. Necessary to decide the real dispute of the case, my lord. It is necessary. Otherwise, my lord, after the long litigation, it will be impossible to execute, my lord, again, my lord. And this nothing will prejudice the plaintiff, my lord. He cannot prove my lord, prove anything before your lordship that it will prejudice him. Nothing, my lord. My lord, the same cannot be properly decided, my lord, without this proper, my lord, boundary, my lord, correction, my lord. It is just for clarification of the existing boundary given, my lord. For just as a clarification can be said, my lord, and will not affect them in any way, my lord. My lord, the law is that, my lord, the procedure should not outweigh the substantial justice, my lord. Not causing any prejudice, my lord. Bona fide, my lord, will create confusion without the correction, my lord, later on, my lord. Now, my lord, in this regard, my lord, if your lordship permits me, kindly, my lord, this honorable court judgment is there in this regard, very clear and
Just a second.
almost squarely covered, my lord. My lord.
The land, which is the disputed land or the suit land, you have your cases that you have purchased this suit land and the other cases that you have not purchased it or whatever.
Something they are disputing my suit.
Now, the question is that whether if there is no amendment on the southern side,
Yes, ma'am.
that will also cause any prejudice or any
Yes, my
effect
lord.
to the case
Ma-
of the
yes, my lord.
petitioner, of
Yes,
the
my lord.
plaintiff also?
Yes, my lord. How, my lord? How it is, my lord? Entire plot of land,
No,
LPC.
you are saying that may not cause any prejudice to the other side.
No, my
Okay.
lord.
But whether this changes is required for their adjudication of the matter also?
Yes, my lord. Because, my lord.
Because this is the suit land.
Because not for them, because, my lord, the suit land, the second part of Mumit, third part sold to Mumit, all are of the larger family members' land, my lord. They are joint property. So it will get serious confusion later on, my lord. Because entire land, these 3 plot of land, including my suit land, I have purchased, is originally belongs to the same family, larger family. Those who are residing in different parts of the state now, for now 30 generations, my lord. So if it is not corrected, it will create confusion later on, serious confusion, my lord. Because all belong to the same family, larger family. That is the main problem. Now, my lord, kindly, your lordship, kindly, in a similar issue, my lord, kindly come to the judgment, my lord, this by this honorable court, and very elaborately and very squarely discuss, my lord, when, how, where, my lord, it can be taken into consideration, my lord.
Work with 10.
No,
Which para you are insisting?
My lord, the honorable court has quoted, my lord, paragraph 17, my lord. When the suit is to immovable property has been decreed and property is not definitely identified, the defect in the court record caused by overlooking the provision of section over 17 rule 3 and 20 rule 3 of CPC is capable of being cured. After all, a successful plaintiff should not be deprived of fruits of decree. Resort can be had to section, similar case to the my lord, the deponent also, my lord. Resort can be had to section 152, section 147 of the CPC. Depending on the facts and circumstances of each case, which of the two provisions would be more appropriate, just, and convenient to invoke. Being an inadvertent error not affecting the merits of the case, it may be corrected under section 150 of the CPC by the court which passed the decree by supplying the omission. Alternatively, the exact description of decretal property may be ascertained by the executing court as a question relating to execution of discharge for satisfaction of decree within meaning of the section 47 CPC. A decree of a competent court should not, as far as practicable, be allowed to be defeated on account of an accidental slip or omission. In the facts and circumstances, the present case, we think it would be more appropriate to invoke section 47. My lord, then come to kind lord, my lord. His lordship quoted some paragraph from the my lord famous judgments, my lord. Paragraph 9 is my lord included there, and paragraph 5, my lord. And this paragraph 5 was the quoted paragraph 5, my lord, in page 4, my lord. Having heard learned counsel for the parties, we are satisfied that the appeal deserves to be allowed, as the trial court, while rejecting the prayer for amendment, has failed to exercise the jurisdiction vested in it by law, and by the failure to exercise it has occasioned a possible failure of justice. Such an error committed by the trial court were liable to be corrected by the High Court in exercise of supervisory jurisdiction, even if section 1 by CPC would not have been strictly applicable. It is true that the plaintiff appellant ought to have been diligent in promptly seeking the amendment in the plaint and at an early stage of the suit. More so when the error on the part of the plaintiff was pointed out by the defendant in the written statement itself. Still, we are of the opinion that the proposed amendment was necessary for the purpose of bringing to the fore the real question in controversy between the parties, and the refusal to permit the amendment would create needless complications at the stage of execution in the event of the plaintiff appellant succeeding in the suit. My lord, in the light of the facts of the present case, where the amendment sought for does not change any pleadings of the plaintiff, but it seeks to correct only the boundary as well as the DAG number of the suit land. Therefore, here might only boundary, not DAG number even, my lord. We are changing only the boundary, just naming the change of person owner, my lord. Land. Therefore, merely because there is a delay in approaching the court of for amending the plaint, it would not disentitle the plaintiff to correct the description of the suit land in the plaint, as it has been held by the Honorable Supreme Court in case of Pratibha Singh Supra, that misdescription of the suit land even be corrected at execution stage. Even at the execution stage, it can be corrected, my lord. Under section 47 CPC, and also by invoking section 152 CPC. Hence, by following the ratio of the said case of Sajjan Kumar Supra and Pratibha Singh, this court is inclined to allow the prayer for amendment by holding that the learned court below had committed jurisdictional error in not permitting the amendment if the description of the suit land, which appears to be contrary to above cited cases of Sajjan Kumar, so and so, my lord. In our case, my lord, what happened? Only WS is filed at the preliminary stage of the case, not that it is advanced a lot. And the learned, my lord, Supreme Court and High Court is saying that, my lord, at any stage it can be if it is necessary, my lord. My lord, there are, I will paste your lordships, my lord, some relevant judgment, my lord, for your lordship, very simple and short, my lord. Then see principal.
Okay, sir.
Copy 9.
Without supplying me any copy, lordship, of the judgment, lordship, I don't understand my learned friend raising the issues of law. My lord, it affects the merits of the case, lordship. With all respect, lordship, because if this amendment is allowed, lordship, then the entire rectification deed, Lordship will come into record, Lordship, which I have not challenged. With all fairness, I'm submitting. Lordship, the learned court rightly rejected because there is an injunction, stay order, Lordship, from the learned court below, not to change the nature and feature of the land. That boundary also will affect, Lordship.
My lord,
So what my learned friend is referring without serving me any copy of the judgment, Lordship.
my lord,
And first judgment will not be applicable in my case, Lordship, what my learned friend has read out, Lordship.
my lord, kindly take the 2018 2SCC 347, my lord. Kindly take, my lord, 2018 2SCC 347 NC Bansal, my lord. I'm giving the short, just my lord, hints, my lord. Your lordship will understand very simple cases, my lord. Second paragraph, my lord. Starting with in respect of the three parameters, my lord, settled by the Supreme Court, my lord. Kindly see. In respect of the application of Order 6, Rule 17, exactly my case, my lord, held when suit is still at initial stage, that is when trial has not yet begun. Our trial has not begun yet. Where proposed amendment would not change nature or cause of action. Nothing will change, my lord. Where applications are not filed at belated stage, not before, my lord, very initial stage, my lord, just WS is filed, my lord. Nothing progressed, my lord. Under these circumstances, court should be liberal in allowing proposed amendment, my lord. Just I showing to your lordship. Then kindly, my lord, I'm not going to details, my lord. Just headlines. I'm showing to your lordship. Kindly take the next, my lord. 2018 2 SCC. Short cases 132. Parties trial when commences, my lord. Para 17 only, my lord. Only para 17. Although order 6 Rule 17 permits amendment in the pleadings at any stage of the proceeding, but a limitation has been engrafted by means of provision to the effect that no application for amendment shall be allowed after the trial is commenced, reserving the court's jurisdiction to order for permitting the party to amend pleadings on being satisfied that in spite of due diligence, the parties could not have raised the matter before the commencement of trial. In a suit, when trial commences, Order 18 CPC deals with hearing of the suit and examination of witnesses. Issues are framed under Order 14 at the first hearing of the suit. The court, after reading the plain and written statement and after examination of examination under Rule 1, Order 14 is to frame issues. Order 15 deals with disposal of the suit at the first hearing when it appears that the parties are not in issue of any question of law or fact. After issues are framed and case is fixed for hearing and the party having right to begin is to produce his evidence, the trial of the suit commences, my lord. Only that stage commences, my lord. Look, it is not yet in the very preliminary stage, and my diligence is proved from the rectification deed because I have collected and requested all the 70 members from entire state, my lord, taken them to Koimganj for rectification of the deed, my lord. They have sold it earlier to me, and I came to know only at the time of the my lord ADR, my lord, in the my lord mutual sitting, my lord, which is not so. Then I came to know only, and because of that, I have went to the extent of rectification, did these expenses and all the expenses of taking the people from entire states, my lord. I see the addresses, my lord. And I have this rectification deed is done executed by all 17, my lord. And I have filed singly, my lord. I have purchased the land, my lord. So I am the sufferer, I am the victim, my lord. I will be suffering the consequences, my lord, either positive or negative, my lord. So, my lord, in all the courts regarding amendment of plaint or WS, the court said that, my lord, is opinion that your lordship is very much aware of all these things, my lord. There is to be liberal, and if any correction is not allowed, my lord, later on there will be complicacy. It will be fruitless for all kind of litigation at the stage of execution. Then again, my lord, that's my submission, my lord. If your lordship, my lord, kindly see, my lord, the purchase deed rectification deed, my lord, it is submitted in the additional WS, my lord.
Okay, pass the order.
Lordship, please. Because if my last submission is that if this amendment is allowed, entire suit will be lodged in troubles. And that part, there is an injunction lordship, how he can change the nature, change the boundary lordship. And original deed was in 2017. After filing WS 2022, they came with a rectification deed. How it is lordship? How he came to know that? That means he have no existence in that site lordship, for which he is stretching on that it will not affect. And lordship, one line, lordship, I am submitting, unless the court comes to the conclusion that in spite of due diligence, the party could not have raised the matter before commencement of the trial. Any stage I know, amendment can be, but that amendment will affect the entire suit lordship. So this much is my submission.
My lord, how have disturbed the injunction, my lord? I have not changed anything, my lord. Only some boundary I have not
Boundary was
changed.
not there.
Status quo was there, my lord,
How-
not to do anything on that. I was going to construct a house on the day, allowed me. I have not done it. I
That means
maintain
he is
that
forcefully
part,
done it.
only my lord correction is done.
He is
On
able-
record.
My learned friend is able to collect all the respondent from Assam state ADR, but that portion is not at all in his petition lordship, what my learned friend is submitting. With due respect, I am submitting. This much is the much of it.
Oblige, your lordship.
Delivery. And delivery. No, license. Delivery of order document. Delivery of order of right document.
Lordship may kindly pass over the item for the timing. My senior, Mr. O.P. Bhatt, is on his legs in another court. Timing.
To, I don't know, may not be possible. There are many more matters are there. So if it comes, we'll definitely will take it up with the matter.
Lordship.
For timing, we have KP.
Lordship.
Lordship, for the timing, your lordship, Mr. Appellant, youngest counsel,
He
Mr.
was
Bhatto.
here only in the morning.
Yes, he was here. But let it be taken after 5 to 10 minutes, your lordship. Oblige.
So to repeat it, point. Last year's of for the applicant. It's a matter of 1 week, as then will be fixed by the next. You know, yeah. It will there. Set of things. Upper must be 9 little. It's from 9. Non-appearance for the appellant. This matter accordingly and then it will be by the next. Alam was. রাখিবা দেখিছিল মই একটু ও ডেভেলপমেন্ট আছে কিন্তু যদি ব্রেকআপ যদি আকি যায় ব্রেকআপ যদি দেখানো তাহলে পিপি যখন এটা থাকি যাব
In number 17 and 19, Lordship.
Yes, one matter was there which you, which 17 is time being.
Time, 19 and Lordship, it may be taken.
19, your presence is not there, was not there. So we just evident you absent. What to do?
Lordship,
After 1 week, we have written it after 1 week only. Nothing adverse after 1 week. In regards to item number 19. But 17, the other prayer was there from the London that he was hurt. So we are going to hear this one, F17,
Lordship.
item number 17.
Item number 70.
Okay, this is an appeal filed by the insurance company against the judgment passed by the Tribunal Lordship. The main ground of the appeal is that at the relevant time of accident, the driver did not have a valid driving license. And also we have challenged the quantum of award also. Without any positive evidence, landed member considered the income of the deceased as rupees 10,000. So Lordship, the appeal may be admitted. Lordship.
Okay.
Yes, your lord.
So you are basically for the claimant respondents,
Yes, your lord.
1 and 2.
1 and 2.
3 is appearing. No.
3 and 4, Lordship. In the IA, Lordship, we took paper publication, Lordship. In the IA.
But again, once you take a, we are going to admit the appeal. What to do?
Your lordship, let the appeal be admitted. Already my learned friend have served me the copy. So notice regarding 1 and 2.
No, no,
Wait,
that's required.
so far 3 and 4 is concerned, let my learned friend may take any by usual process also.
You can take one process and subsequently, if you think that as per you, these are these 3 and 4 are the also the necessary party, or if there is
This is
no
necessary.
necessary party, then we have to take steps. We are going to admit the
Yes, usual process.
Mr. KK learned for the appellant, and also had Mr. D. Montal appearing for the respondent number 1 and 2. This is an appeal against the judgment. Judgment and award dated 28/3/2017 passed by learned member MSCT Kamrup M. Guwahati in MSC case number 1267/2012, directing the applicant insurer pay of sum of ₹16 lakhs 5,000 together with 6% interest from the date of filing of the claim petition till realization. Appeal is admitted for hearing as the respondent number 1 and 2 have already entered into their evidence. No formal notice is required to be served. Respondent number 1 and 2. However, the appellant will take steps in issuing notice to the respondent number 3 and 4 to register any and also call for the case report. Please do matter accordingly. After 4 weeks or after vacation? So after Puja vacation as an indicator.
I for the still also we will deposit 50% of the order.
I is also there. You are ready to deposit? I to date. It's a petition for stay of award dated 28/3/2017 passed by member MSCT Kamrup M. Guwahati in MSC case number 167 of it. Submitted by Mr. That they are ready to pay the 50% of the awarded to the payment respondent in view of this. The further the execution of the employment judgment and award dated so and so will be stayed till dispose of the collected appeal with the subject to payment of 50% of the awarded amount to the respondent number 1, and it will be deposited within how many days? You 60?
Within 6 weeks.
6 weeks. Yes. Will be deposited within 6 weeks before the registry and the the money will be, regarding the disbursing, you don't have any issue.
They
Releasing
may
of-
be allowed to withdraw by furnishing one.
No, that is there. If the deposited money may be withdrawn by the respondents, number one and the claimants. By executing the bond, and the money will be released by the list after due verification and identification of the respondents of the
Your
claimants.
Lordship, the award has been passed in favor of the mother of the deceased. So the claimant number one may be allowed to withdraw the
Only mother,
only mother.
claimant number one. Okay, we'll respect the claimant number one.
Highly obliged.
I used.
Met your lordship. My lord, the petitioner behind the above for the last 83 days, only 7 days to 90 days. On the last occasion, this terminal court is directed regarding the arrest of the co-accused, the prime accused is concerned, my lord. And thus, because of unable to arrest the prime accused, I am behind the bar for the 83 days. Though I have myself surrendered before this authority.
So you are how many days? 80?
83 days, my lord. For 83 days. And lordship, the last order, lordship, the earlier rejection order at page 41. On merit, lordship has recorded all this. Paragraph 4 and 5, lordship has already recorded the background of the case, my lord. So, and ultimately, lordship has given conclusion at paragraph 8 and 9, page 44. Regarding the other culprits are may involved in this case. So, at that stage, lordship has considered on that occasion. So, on last occasion.
Spot on the merit, we have seen already there are some.
Yes,
On the length of detention.
only on the length of it.
Because you think within 7-8 days, most
Yes.
probably may not be possible.
Yeah.
Case is still under investigation.
Yes, madam.
Case is still under investigation.
Yes, still in.
By Mr. P.K. Tekka, the land consultative petition. By Mr. B. Watt, the land petition, be paid on the opposite. This is an application, section Swens, connection Swens. Is there we have received or no?
Yes, please, there is.
Is there did it receive? Where is this? It is submitted by Mr. Tekka. His earlier paid application was rejected at school on 30/07/2020. After considered the materials in the case diary from the board. But petitioner as on today is in custody for last 83 days, and hence considering his length of detention, there may be concern. However, the petitioner being the permanent resident of said locality, there is no chance of confounding, and will extend his cooperation regarding this case if he is granted with the privilege. Extra bond. Done in addition, people submitted that there is sufficient informative materials to consider the petition. However, it is the fact that the case is not in charge sheet and investigation still is still under process. Without going into detail into the merit of the case, considering the fact that the petitioner is in custody since last 83 days, and the investigation still under process. In view of this, we consider the detention. The petitioner, in whose satisfaction this one?
District Court, no?
CJM, my lord.
Sonitpur CJM, my lord.
Satisfaction, CTM, sir. Good. Okay, you did.
Yes.
Deputy obliged.
I was arrested on 76 days, same matter. I'm a co-accused.
I don't know, we there to be on 7 days, we considered. Earlier also, your petition was also.
This is second bail application. That was also rejected on merit.
No, that was.
Oh, that Ria Paul.
Ria Paul.
That's the lady. Yes. Is Potakur, I can still remember there are sufficient materials against
Yes.
her also in the, though she was not the employee of the
Yes.
other company, but
Yes.
still she received all these things. Now what to say, what you want to submit, because merits are there.
Other materials is there, my lord, only on the ground of length of defense. Otherwise, my lord, materials is there against like my lord, from his house. My lord,
Yes, yes, there are some
recovery is
gold
also
plate.
recovery is also there.
But the investigation, the last part is what it says, it is still under investigation.
Investigation.
There are some,
Yes.
one prime accused is.
Yes,
he will be arrested.
Moon Ahmed not yet arrested. No.
He is not yet arrested.
Yes, not yet arrested.
He is the prime minister. He was having the custody of all those gold ornaments alleged to have been misappropriated. And one gold ornament was found from my possession and other were still lying in the bank. It was reinvested, those gold ornaments, where I am involved. Right? Those,
More or less same order of Jadal of Alam. Earlier rejected. I don't know. Report for submission. Also submitted that one of the prime ministers of this case, Moon Ali, is yet to be arrested. And case is still under investigation. Okay, your.
okay.
Here, my lord, POXO is there, whether notice is served or not.
My lord,
My lord, make legal logic. This case today only I got the instruction from my client over phone that they have already handed over the possession because there is a degree of recovery of possession. And they are going to enter into some settlement logic. So let the matter be listed after this vacation. So we will get the proper instruction from our client. You also.
My lord, I was also awaiting instruction. There was a talk of settlement, but we have not received any written instruction. That's why it has become difficult for me to submit before this court about the settlement part. So if time is granted, my lord.
So you're for the appellant.
Appellant, my lord.
You're Mr. Khatonia?
M. Khatonia.
M. Heard Mr. M. Khatonia and also for the appellant. And also heard Mr. You're Mr. Deka?
J. Deka.
J. Deka, the learned counsel, the respond. Mostly the learned counsel for the appellant as well as the respondent jointly submitted that there's a talk of settlement is going on between the parties. And that apart, Mr. Deka submitted that as per his instructions, they have already handed over the position of the disputed land. And accordingly submitted that sub instructions is required and paid for it. Prayer allowed. After vacation we'll do?
After vacation.
After
In the
vacation.
meantime, both the parties.
Yes, both.
Yes.
Is the matter accordingly after vacation. Enabling both the parties to take proper instructions of from the appellant as well as.
Obliged.
Obliged.
May I please, your lordship? My lord, this is the second appeal, my lord. Though it is a concurrent finding, but here in this case, my lord, I am the plaintiff and suit of the plaintiff was dismissed on the count that on the basing on an unregistered sale deed, the suit is barred by limitation, my lord.
Before that, my lord,
Just I want to.
Part by
clarify one
limitation.
my
thing.
lord, before going to the merit, my lord, my one submission, my lord, that IA for condemnation was allowed subject to payment of some amount to the.
That was
I
paid,
think
that was
my lord.
paid.
I do not know whether it is complied or not.
Complied,
But
that it was complied, that is why it has been numbered and registered as RSA.
My lord, number two, my lord, we have provided through notice only the IA of the copy, my lord. No RSA copy is given to us till now.
No, he is not, after, my lord, at the time of issuance of in delay condonation petition, he is entitled only for IA. Now is, today is the first time, my lord, this is this first, second appeal, my lord.
I may be given a copy, my lord, that I can, my lord, make submission before your
If
lordship.
it is admitted, then only he is entitled for copy. my lord.
Now see, the question is that.
Whether it will be
actually this
admitted or
this
not,
the-
There is no bar.
This is,
There is-
what had happened, you are rightly submitted one thing that at present he is only entitled to this thing, notice only, but the question is that here, these cases have been fixed for.
under order 41.
Under order 41.
Yes, my lord.
Under
Order
41.
41.
So as he has already appeared, so that is the issue. Otherwise, under 41, we have to hear the appellant side, whether it might be, can be appealed, can be admitted for
Or-
hearing or not.
Yes.
But the question, he has already entered into appearance because condonation was there. So rightly or wrongly, but that is the case. So now you have to supply it with, otherwise at this stage, without hearing the other side, we are not in a position to pass any order regarding the admission also.
Yes,
That is the
yes.
case. Then
That is
what
the
to-
that
what
is
to
the
say?
position in law.
My lord, we have appeared, we are appearing in every day.
In order
Today also-
41, rule 11, he has no
Neglect that I
right.
am appearing, my lord.
He has no right.
Otherwise, he had no right. But
No right.
as he already entered into appearance, then what
Even
to
then,
say?
even then,
Then
if
even-
it is
And
admitted,
he has already.
after hearing, may I read the provision, my lord?
Provision
he-
is already there.
Yes.
I know the provision. That's why I'm asking.
Yes.
He has already entered into appearance, so what to do?
I will give copy. That is no problem.
That is the
I have no
questioning that
problem.
only.
Now only today is whether it will be admitted or not. That is the only question, my lord.
But in that case, if
My
he
lord,
has
on the last
submitted-
If it is admitted, I will give copy. I have no hesitation to supply the copy.
My lord,
I
before
will
that,
show that whether it is an admissible case or not, my lord. I will show one paragraph.
my lord,
it
no,
was-
no bar, my lord, I should, I have appeared, my lord. Already in the last occasion, they said that they will supply to me. On the last occasion also, I mentioned at that IA stage, that they will supply to me and I will appear, my lord. But they have not given it till now. They might forgotten or no, I do not know.
Now, the question is that as it is under 41, but the question is when the actual fact, I mean, it is to be decided hearing the appellant side, whether it can be admitted for hearing or not.
Yes.
One point. But as you have already entered
Appeared,
into appearance.
yes.
The,
And no
now
bar,
the
my lord. There
question
is no
will be
bar.
a bit
Yes,
different.
yes.
That is the issue.
And
So
there is no
do
bar.
One thing, what I am suggesting, you can furnish the copy to the other side.
Yes, I will furnish.
Then it will be in the
I have no-
admission stage itself, in the time of a hearing, if it is, can be, this is a case of admitting the appeal on the law points and all, then it will be.
Yes.
It will be more convenient before, my lord, for the
It will
honorable
be
courts, my lord.
convenient because
More
otherwise.
there is no bar, my lord, in my appearance, my lord. I can place on the, everything is on record, my lord. I can place my submission, my lord, even
My
though.
lord, it may come out on Wednesday, my lord. I will supply copy during the course of the day.
Wednesday, I don't know, list is already.
On Friday?
Only Thursday, just tough copy nine. Bilang Anil Baba like.
Oh, Friday is holiday, no?
If they need it, if they need it, next week we do full marathons. Oh, bro, yes. Then I come. 16 months. Actually, what is difficult on our part, the civil bench was taken by the other bench. So we are not in a position the amount what has already been fixed. So that part, we are just fixing it on 16th then. Will it be okay for you, 16th?
16th of
16th of this month only,
this month.
September.
My lord, maybe 17th is not any problem. Maybe on 17th, my lord. 16th, I have some, even if your lordship has convened. 17th.
17, you are not interested to fix.
Then my lord,
Matters anyway.
my lord, otherwise it will come on motion day. It will come on motion day because it is the
Motion
first
day, I don't know whether it will be listed or not, because
It will
from,
be listed.
no,
If
just
they
a
are,
second, just a second. It is from 22nd onwards, this week will be the motion week. From the 22nd
no,
of September,
I'm
26th.
praying on 15.
15 can be otherwise.
I'm praying on 15.
So by that time, you are going to supply the copy.
Yes, during the course of the day, I'll provide the copy of the second appeal.
15 করে দিও। This one 15 করে দিও। And the copy of the memo will be supplied to the respondent during the course of it. List the matter. Okay, we are listing it on 15.
My lord, he is appearing on behalf of
My lord,
all the respondent.
For all the respondents, you are appearing. Mr. Shalabhadra?
Lord, I have to check the records, my lord.
1, 2, my lord, not all perhaps, my lord. 1, 2, 10, 11, 14 and 16, my lord. Not all, my lord. 1,
In,
2,
in
1, 2,
other
10,
petition, delay
11.
condonation, you appear for only for them only. 1,
1, 2, 10, 11, 14 and 16.
1, 2, 10, 11.
11, 14 and 16. Not
Let me
others.
take it, right. Okay, listing on 59.
Much.
Other rest of the
It was
respondents,
earlier served.
it's not served.
It was served, that
Served.
is why delay was condoned.
Because apart from you, there are
I'll
names
have
of
to
1,
My lord,
2,
if the
3,
re-
4,
if-
5, 6. 6 numbers of this council's names have been reflected.
My lord,
in
if the office note of the IA, my lord, is checked, my lord, it will be clear, my lord. If the office note of the IA, my lord, already condoned, it will be clear the service notice was served
No,
or not.
they have already.
No,
entered in it because-
after admission, if he is not appearing on behalf of other respondent, I will have to take press steps on the
Otherwise,
second.
there are 6 numbers of name of the councils have been reflected.
Yes,
Here. So most probably. if that
maybe they are
confirmation-
appearing for others.
Appearing for the others. Okay, then we'll see to it. 59.
Much.
25.
May I please your lordship? Lordship, I beg to mention item number 25. Matter can be passed over for the time being because my senior is on leave.
There are many matters. It may be time being, but I don't know. Anyway, okay for time being. Okay, then fine. Only for- Oh.
May I please, Lordship? Lordship, item number 43, Lordship.
Yes,
I have
43 is connected with
Yes, Lordship.
this 26.
Yes.
Ah,
Lordship, I have for correction of order, Lordship.
This is for correction of order.
Yes, Lordship, order, Lordship, annexure. Annexure D, Lordship, page 15, Lordship. Lordship, correction, Lordship. Lordship, in this order, Lordship,
Where is your
step was taken on
15, page number 15 of
15,
of your
Lordship.
IA?
No, Lordship,
Page number-
RSA, Lordship.
No.
Page-
Page number 15 of your IA.
Oh, yes, Lordship,
IA.
yes.
15
I
is
Lordship,
the
page number
names.
15, Lordship, annexure D.
Annexure D. Short order is there, list again.
Yes, Lordship,
Ah.
respondent was wrongly written, Lordship. Instead of 1 and 2, Lordship.
Listed of 1 and 2.
Yes, 1 and 2, Lordship. And here, Lordship, written, Lordship, 1, 1, 2, 1, 3, 2, 1, Lordship. They are, Lordship, appellant, Lordship, not respondent.
মই কেনেকে কম দেৱাশিস বৰুৱাৰ ঘৰ। দেৱাশিস বৰুৱা। এখানে আছে। No, civil bench রয়েছে। Putting up with them. No, মই তেওঁ থাকা অৱস্থাত কাৰেকশ্যন কেনেকে কৰে সেইটো। আৰু এইটো তেওঁ এফেক্ট কৰিব নেকি? How this, anyway, this is cannot be corrected by me, one thing. And second thing is, will this cause any prejudice to you? This disorder? How?
Lordship,
Main case to kill.
order was passed in RSA, Lordship. For, order dated Lordship 5, Lordship 5/5/2025, Lordship.
Original suit. Oh, main appeal to memo to court. It to order है appeal memo to court. It not horrible. No, it to order. It is the other sort of heavy. It is heavy enough. Memo. Brown system. Second appeal है it we are oh चाहिए 8 lakh 1.2 1.3 30 problems. It's a 1.2 1.1 it must say no steps upon 1.2 they can't really amend it which is no killer. Just I'm not following you. This order 5/5/2025.
Yes, Lordship.
There was an order to take steps where you were you were appellant.
Yes, Lordship.
You are the appellant.
Yes.
So you were directed to take two steps on respond number 1.1, 1.2. These are amended.
11112, they are appellant, Lordship, not respondent. Respondent only, Lordship, 1 and 2, Lordship.
Who died? The appellant number 1.
Yes, Lordship.
Appellant number 1
earlier-
died.
Yes. Earlier, Lordship, I have for substitution, Lordship. Order, Lordship.
No, yes,
And-
I can understand now. Your one substitution was there, and on the basis of that, your appellant number 1 died
Yes, Lordship.
during dependency. So for the substitution, now it is substituted 1.1, 1.2,
Yes.
1.3.
They are substitute.
And the 2, 2.3, these are also substituted. These are all appellants.
Appellant, yes.
নাহিলে হলো আর কি হবে না। So now 1.1, 1.2, these appellants were represented by anyone now? Who is representing now?
I also.
You are representing.
For us, all the appellants, Lordship.
All the appellants you have already responded, representing.
Yes.
Then they do one thing, you
Lordship,
do not
state-
go for the IA then. IA is for modification or correction. That has
Yes.
to be done by Justice Burwa only.
Yes.
Again, you have to place it before that court.
Yes.
So what I'm saying, because maybe because of there are problem, so your submission may be recorded then. IA may not be disposed of.
I already disposed, Lordship.
No. Need present IA 43.
No, today is Lordship first day, Lordship 40.
No. You withdraw this 43 and we'll pass this general order.
Lordship,
General order in a set, inadvertently, the order was there, it will be already responded, you have already represented all the amended, the substituted appellants, that only we can record it.
Okay.
I mean, you are insisting on the correction of the order.
Correction of
okay?
orders, Lordship.
So what I'm saying that this order, if it is, suppose it is not corrected also, it may not harm you because we can record here that inadvertently the appellant was directed to take steps on respondent, but they are implemented as a appellant.
Yes.
which the appellant have already been represented.
Yes.
Isn't it? That can, order can be passed.
But, I can take steps now, upon respondent number 1 and 2, Lordship. But here,
Why
Lordship,
would you take respondent on 1 and 2. Is there any amendment or is there any substitution of respondents also? No.
already substitute, Lordship. Lordship, NHRC, Lordship, page 30. Lordship, kindly see page 14, Lordship.
নহলে মই inadvertently লিখি দিম। available. ঠিক নহয়, আজি কৰিম, কালি দিম। Time required.
Lordship, kindly see
Just
page
a second,
14.
miss, you will take some instructions whether it can be placed before the appropriate bench because the bench is still available.
Yes.
The court is available. So we'll take instructions. After some time it will. Twenty-seven, you are for the respondent.
I am for a response.
So how many, the steps have, the process is already completed. Service is already completed.
No, Lordship, on respondent number 2 and 3, I am for respondent number 1. Lordship, may produce the last order, Lordship.
Last order also, they were not present,
Yes, Lordship.
appellants.
Yes, Lordship.
And otherwise also, you are bidding for whom?
Respondent number 1, Lordship.
1. And how many respondents are there?
3, Lordship.
3 respondents. 2 and 3 are there. So what about the service on 2 and 3? No fresh steps.
They were there.
They have not taken any steps. Then appears on call for the appellant. Third, Mr. You are Mr.
C. Sharma, Lordship.
C. Sharma, appearing for the respondent number 1. Office notice dated 24/06/2025. Legal step, no fresh steps has been taken for the respondent number 2 and 3 by the applicants. And the applicants also remained absent since last 2 occasions.
They have not appeared in earlier dates also.
Yes, since last 2 consecutive dates. In view of this, list the matter accordingly after 2 weeks as on a date to be fixed by the registry and in default. The appellant consequential order. Consequential order may be passed accordingly if they remain absent on the next. Next date also, if they remain absent, then we will pass an order for consequence.
Yes, sir.
Yes.
No, in this case, actually, it is for orders, but then I am not very sure. It has not been uploaded. The LCR has been called for, LCR is arrived, but then,
This year,
there is a I also where in which we already got a stay order for the execution part, and then I pray that may be continued.
We have received the TCR already.
Yes.
And what about the,
I know there is an execution suit actually pursuing in that lower court, and then in there we got a stay order in the last occasion, and then that stay order may be continued. And like here, this case may be fixed for hearing, but then
there was
respondent,
an order for substitution also.
pardon me? Yes, the
Substitution
for
of-
that we have already submitted the title. Title deed we have already submitted. Substitution order was there, yes. The dependent respondent number Mohad Das was one, Mohad Das was expired and accordingly there was a substitution petition we have filed and on that we have already received an order. I already filed.
So in the last, in the order of this 11/9/2024 also,
Pardon me?
it reflects that the respondent number one most probably died.
Yes, he died and then.
So the
all-
appellant shall take necessary steps to impede the legal heirs. Have you
Yes,
taken
we
any
did.
steps?
We did. We did. Two, four. I
In
was
a
dis-
sense, do you file any aid in that?
Yes,
regard?
we did, and then that I was disposed actually. We are allowed to substitute. This the 2469, something like that.
2924 or
2099 is the IA for stay order, and then there was another IA for substitution, which was disposed.
so you have filed your amended cost, I think?
Yes, I did.
So Mohad Chandra Das, he died.
Yes, Mahasundar Das is that. Your Honor, actually, in this case, I have not seen the other respondents, advocates appearing in the cause list. But they have already made appearance.
Have you filed your amended cost title here? Amended cost title?
Yes, I submitted. It's,
No,
if
you
it is
haven't
not in the
posted
record,
it.
then I'll submit again.
Amended cost title report. No, no, yate. The notice. There's a no note regarding the filing of amended cost title and we have not. There is I cannot find it here. You're saying that you have already filed your
Yes,
amended.
we
cost
did,
title,
but on the
no.
second day, the same date, actually, I have submitted. The same date I have already filed it. My lord, I will verify it in from the filing section, and if it is not there, then I will refile it again. Amended cost.
How many legal years he left behind? That respondent number one, how many legal years he left behind?
Two.
Two.
Aruna Kakuti and Parthapratim Das.
Okay, then you take instructions from the consent section and we will also verify it. But here we are not finding it. And
Sure.
there's no.
I
note
will
in that
verify it
regard.
and from the filing, and then I have got the receipt actually, when I have filed it. So I have, with that I will verify, and then if it is not there, then I will verify.
Your good name is?
S. Goswami.
Goswami. I heard MS S. Goswami. counsel for the appellant. From the, it is submitted by her that after the date of the respondent number one, Mohan Chandra Das, the prayer was made to an interlocutory application for implement of the legal layers of substitution of the legal layers of the respondent number one. And the prayer was accordingly adopted. In person to that, she already filed the amended post with the implement of the legal layers of the respondent number two. Respondent number one. But the amended post title is not found available in the case record. In that regard, she submitted that she may make an inquiry with the respective sections. Stop. The MS Goswami is accordingly asked to take instructions from the respective section, and it is not filed earlier. Fresh amendment post title may be filed. Further, it is seen that no one is representing the other respondents. Notice is served only for the other respondents. Notice for the other respondents have already served.
Yes, my lord. Other respondents have been appearing actually. I know. But then why they are not here now? I don't know. Today, because their name is also not in the cause list, but they are supposed to be. Because they have been appearing 2-3 times.
They are directed to reflect the name of the counsel who is appearing for the respondent event. Please the matter accordingly after puja vacation. After vacation will do, after puja vacation.
After puja vacation. Your lordship, one thing more, like there is a another IO 2099 in which there is a stay order for the execution case. It has already been stayed, but that case that should be continued. There's
It's
another
already stayed, I number, you just.
2099.
2099, 2099, I have seen. In one hand, it is here that therefore the further proceeding of the title execution case number 22/2020 pending in the court of learned civil judge number 1 Kamrup shall remain stayed. But subsequently one date is there, the list is matter after 2 weeks. So it is not finally.
No, I don't understand, but there was a, this case was totally, is there 2 files running in this case? I do not understand because like in that I have already filed that, my lord, and then in PJ Soike's, Justice PJ Soike's court, there was a order passed in this, and then in that order, we got stay order accordingly.
The stay is there.
Yes.
Undoubtedly, stay is there.
Yes.
Last, we is that so and so shall remain stay. That is
Yes.
there only.
Yes.
But again, this matter after 2 weeks is there. I delay stay kora hai sir. But stay is operating, I think.
Yes, stay is operating.
Stay is
Yes.
operating. And do you need any clarification on that? The stay will be still
Stay
huh?
should be continued, my lord. Otherwise, there is execution suit cannot be continued.
Pardon, the order of stay dated 10/2025. Passed in IAC 2099/2020. We continue till next time.
And
মই inadvertently নকৰো inadvertently কামতে আপোনাকে কৈছো তো মানা নাই নহয় সেইটোৱে কৈ তো মোক আপুনি এইটো withdraw কৰক মই inadvertently মই সেইকাৰণে কৈ আছো যে আপুনি withdraw কৰক এইটো আপুনি verification নাম লাগে মই লাগিলে অৰ্ডাৰটো verify কৰিম নামানে নহয় বলে নামানে নহয় মোৰ we clarify the matter, it may be listed before the appropriate bench, but what I'm suggesting is he has talked with the concerned section also.
Yeah.
you may withdraw this one. No use of it. You may withdraw this one. This IA.
Yes, sir.
We will pass a corrected order. That inadvertently it was so and so, but it has to be so and so. That order can be passed.
Lordship, I need to instruction from my senior lordship for withdrawal.
List after puja petition.
Yes.
And the consent with the request made by the consent petition. Appellate is the matter accordingly after puja petition. কোনটো নম্বৰ আছে এই দুইটা পূজা ভেকেশন সব কৰি দিম ঠিক ইমান বুজোৱা টাইম ন টাইম এই 42 আমি হেৰি কৰি দিম পূজা ভেকেশন next one.
Your Lordship. My lord, as per the office note 29 August 25, my lord, service for the legal heirs of respondent number 1 is complete, my lord.
You have already appeared.
I have already appeared for some of the respondents.
Some other respondents.
Some of the legal respondents, 1B, 1D, E, F, 2 and 4.
But office note, my lord, all the respondents regarding legal heirs of respondent was completed. That means service complete, my lord.
So you are appearing 1A,
1B,
1A, 1B,
not 1A, Lord. So
not
1B,
1A. It's a 1B,
D,
1D,
E,
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 1E,
F,
F,
2 and 4.
2 and 4.
One mark on the Eki Kurkuri. Marking master put a key. Mark or beleg. Already, my lord, record receipts, my lord, and this matter has already been admitted on 28 August 2020. So let it become for usual hearing force.
No, hearing will come subsequently. Service is not yet completed.
My lord, service for the legal heirs is completed, my lord.
No, he is appearing for 1B,
Service
1D,
complete since-
1E and 1A.
Either has to
Lordship, I have only instruction to appear for some of the respondents.
2
Next
and
item.
2 and 4.
This, my lord.
service complete, my lord, for the 1 legal heirs. As per the office note dated 29 August 25.
29 August.
Yes, my lord, office note can be perused, my lord.
Lavazima court.
Lazima, yes.
Lavazima court.
Lazima court, my lord. And last line, my lord, service for the respect for respondent so and so all the has been completed. Since
Where?
in bottom last line, my lord. Since my learned friend is not appearing 1A, that is different issue, my lord, but service is complete, my lord. All of family members.
No, you have the one portion only in respect of the notices issued through the AD.
Yes, my lord.
In this regard, it appears that the AD cards for the respondent number 1A and
Yes.
1B have been received, but the said AD cards
In the
bears
regular,
signature of person.
the usual
other
process,
than
my
the
lord.
addressee.
In the usual process, my lord, all the respondent receives copy.
Where from? Where
My
from?
lord, in respect of notice issued through usual process, that is last, my lord. Usual process, my lord. It appears that the process server reports have been received and perusal of the review. This, my lord, ultimately the bottom line is the following observation. That will receive, my lord.
So service on 1A, 1B, 1D, 1E and 1F.
Yes, completed.
C is not there.
This 1A is one, my learned friend is not representing 1A. There is no instruction regarding rest. The respondent
he
is
not
appearing.
appearing 1C also.
No, not appeared.
Yeah, that's
Let's see, no
okay.
correct.
1C is not appearing. So you can
Yes.
take instruction if they are same family, you can
Yes,
appear.
same family members, my lord.
Okay, then I'll ask my whether
Yes, you take instruction
Okay.
whether you can appear for the legal heirs of 1. Respondent number 1 most probably died.
Yes, my lord.
So all the legal aids, if you can represent that, it's
So
okay.
for my lord, 1A, I do not have any instruction because she is not presently residing with the family. But 1C, I can get the instruction whether he is willing to appear in the case or not.
I could. 2020 matter, my lord, already 20 admitted, LCR received. So, may I pray, my lord? Let him take instruction, once instruction, my lord.
Only for 1C, lordship, I can take it.
For 1C.
1C.
But 1A service is deemed to be completed as per office note, my lord. Yes, office note, 1A service complete, my lord.
Service complete.
Yes. And so for 1C is concerned, my learned friend will take instruction, my lord.
And that apart, how many other respondents?
Yeah, they got?
How many other respondents?
Yes,
are
my lord.
there?
Altogether, my lord. 24.
So what is the other respondents in regard to?
এখন লিস্ট দিয়ে কালকাট হয়ে গেল এবার কিগুলো করে তুই হয়ে গেছে কমপ্লিট তোমাকে এই করতে হবে পরে হ্যালো Well, I need to check the record. You get 24 parties are there, my lord, respondents, my lord. And might be some, my lord, struck down order might be there, my lord. All the 24. I need to check the records, my lord. So far as all the 24 respondents are confirmed, my lord. Only one legal years, but rest 23 respondents. It is the service note, it is their service completion of notes is there or not, I don't know, my lord.
Regarding the other respondents.
Yes,
there
yes,
is no
yes.
such note.
So, my lord, I need
But
to.
otherwise, you are appearing for 2 and 4 also.
2 and 4, yes.
You're not representing 3.
No.
Well, 1 to 6, they are the principal respondent, principal defendant. Rest are
Yes.
pro forma.
Yes, sir.
But 1 to 6, their presence necessary, my lord. 1 to 6, yes.
5 and 6 is the government.
5 and 6 government.
Okay. 5 and 6 come. Hard Mr. Pickett, Learned Counsel for the appellant. So hard. You are Mr.
G. Bharadwaj.
G. Bharadwaj, appearing for the respondent number 1B, 1D, 1E, 1F, 2 and 4. However, he submitted that he can take instructions to represent the respondent number 1C. 1C, but there is no instructions to appear on behalf of respondent number 1A, who is a resident of separate, who is recited separately. However, from the office note, it reveals that a notice under against 1A to 1F has already been served. But there is no note in regards to service of notice on respondent number, other respondents.
Yes.
In the compromise. In view of this, Mr. Decker is submitted that he will take proper instructions from the consent section. And the consent section in regards to notice issued on other respondents,
Yes, my lord.
including the compromise. In view of this, let the matter be listed. After Puja vacation?
Yes, my lord, after puja vacation.
After Puja vacation, enabling both the parties to take proper instruction and also to take and also to issue notice.
Apuni কার হয়ে?
Oh, you are also representing one.
And my lord, the record, I may be allowed to verify, my lord.
Okay.
Deeply obliged.
Lordship, sorry to make a mention, Lordship. Item number 31. In item number 31, Lordship. In this case, Lordship, today I filed the affidavit in opposition, Lordship. Can it be taken up any day after Puja vacation, Lordship? I have taken consent of the other side also, Lordship.
These are not on record.
Huh?
Just now they have served a copy.
of the affidavit, but it is not on record, let the matter will come after Puja vacation.
After puja vacation, lordship.
Along with the affidavit, my lord.
Item number 31, lordship. For the respondent, I file my affidavit in opposition.
For both the instant matter accordingly after application. And the registry is also hereby directed to take the affidavit in opposition if already done. Whose application?
Lordship, leftover matter, item number 16. I am representing the respondent 1 to 18, all the respondents. So I will file one affidavit
Here
in
I have two, that's what I'm saying.
other side.
The accused is hereby released on bail on furnishing a bond of rupees 20,000. Only with one security only will be satisfaction on the learned session just 0. There were some conditions. We have to abide by all the conditions.
May it please you.
Yes,
I'm appearing for the respondent 1 to 18 and
1 to 18.
18.
Ah.
And I will file my affidavit in this case. Sometime maybe.
We are going to file your affidavit.
Lordship.
You are Mr.
SK Gupta.
S.K. Gupta.
SK
Gupta.
Gupta.
Part Mr. S.K. Gupta appearing for the petitioner and also part Mr. You Mr. Gayan
And Bharali.
and Brad. Also part Mr. and Brad. Your name is not reflected here, so is there. And Brady appearing on behalf of respondent number 115. And it is submitted by Mr. Brady that he needs some more time to file their affidavit in opposition. Prayer after Puja vacation will do? After Puja vacation?
After.
Lordship,
Yes.
it may come up in the second week of November. Mr. Bhati will be out of station.
Second week of November.
November.
After Puja will not,
He will not be there. He is leaving on 27th of September.
one thing will post it will after Puja vacation only. It may come in November also.
Lordship.
Because there we don't have posted date, it's second of week. Let it be after Puja vacation. List accordingly after Puja vacation as on a date to be by.
Lordship, interim order may be continued.
Most day, it will be continued till next.
Okay.
My lords, in this case, we have taken steps, but they have not come. So none is.
25.
Two times, yes, two times you have taken steps on 22/11, 24 and on 26/11, 24.
Here is an office note. How many respondents are there?
Hello,
Respondents are 15 respondents.
respondents are 9 and pro forma respondents are 10 to 16. And this is the two times we have taken steps.
Now see, if you go by the this office note,
Yes.
it provides that respondent number 1 expired, 2 expired, and 3 served to his son, 4 expired, 5 expired, there are some accept note through by the respondent himself or through his family members for 7, 6, 7, and 8. Then again 9 expired. So as many as number 1, 2, 4, 5, 9. These are all not the pro forma, but the respondents, principal respondents. 5 respondents have already died. So have you taken any steps for substitution?
For substitution of their legal heirs, then some time may be allowed so that we may collect their legal representatives and thereafter we would file the case.
And we have received most probably both title appeal and the title suit. The records have already been received from the land court below. Records are already there, it has already been received. But service to it's incomplete and that part, substitution part is there.
Substitution is necessary, but we shall have to collect the legal representatives of the deceased respondents.
Yes, otherwise also, the 6, 7, 8, 10, 11, 12, 13, 14, 15, these are served. All are served. And that is that for Mr. Abu Mahmood, the land council petition from the office note dated
From this type.
2025. It is seen that the respond number 1, 2, 4, 5, and 9 died during the pendency of the present petition, a present appeal. In that context, Mr. Mahmood submitted that they will file the interlocutory application for substitution of the legal heirs of the deceased respondents. Further, it is seen that the service on respondent number 3, 6, 7, 8, 10, 11, 12, 13, 14, 15 served, and the service report is also available. In view of this, the appellant is hereby asked to take necessary steps by filing interlocutory application for improvement of
Substitution.
for substitution of the legal heirs of the deceased respondents. This after put application will list the matter.
Vishnu Prasad. Vishnu Prasad.
Meet with your lordship. Because I'm appearing for the respondent number 1, I'm appearing for the first time.
You are for the 1.
Service is complete also.
Completed?
Complete. And
So how many respondents were there? Only 1.
respondent is there.
2. He is for 1. Is 2
And
anyone?
but the respondent 2 has also appeared also.
Appeared.
More on
Mr. R. Goswami has appeared. Yes, 1 and 2.
Yes.
Had Mr. K.K. Bhatta, the learned counsel for the petition. Also had, you are Mr.
S. Vishwakarma.
S. Vishwakarma appearing for the respondent number 1. And from the office note, it reveals that the service is already completed on the respondent number, both respondent number 1. Can it be listed for admission?
It has already been admitted.
Oh, sorry, admitted. Hearing,
LCR has also come also.
I think so, yes, LCR.
In this
LCR
report,
has already been received. List the matter for final hearing for raised table, list the matter accordingly after puja application. After puja application.
May I please lordship? Lordship, in this case, respondent number 3 has entered appearance, lordship, and LCR has been received, lordship. With regard to respondent number 1 and 2, lordship, during the delay condonation stage, although the case was pending from 2019 to 2022, the respondent number 1 and 2 did not appear, lordship, due to several reasons, due to insufficient address and all. Therefore, the delay was condoned. Looking into that aspect, Lordship, delay was condoned. And the award that has been granted by the trial court, Lordship, that is with regard to respond number 3, Lordship. They had to satisfy the award. And before the tribunal also, respond number 1 and 2 did not appear. And they never contested the case, Lordship. So matter may be fixed for hearing, Lordship. Their presence may not be required, Lordship, respond number 1 and 2, Lordship.
No, have you taken state? The last order, I don't know, but in order.
No, I don't think so, because I could not go through the record, Lordship.
Anyway, in the last order was on 12/9/2022,
12/9/2022, that was
where
admitted.
we were asked to take fresh steps on the respond number 1 and 2.
One
You
and two,
complied
Lordship.
with us,
No, Lordship, I could not go through the record, Lordship.
then how can we say? Because
Because-
the
but-
2025 one acquisition notice there.
But their presence
Has
might,
not been taken yet.
yes, Lordship, but their
Yeah.
presence might not be required, Lordship, since before the
That is up
tribunal.
to you, you have to file.
And during the delay condonation stage also, that notice could not be served upon.
Delay may be controlled, but at this stage, you have to issue notice.
Then, Lordship, I may be allowed to take first steps upon respond number 1 and.
Because on 12/9 itself.
Yes,
it was
yes,
directed,
yes,
but you have
yes.
not complied with that.
Yes.
direction. And you are Mr.
P. Mujumdar, Lordship.
P. Mojum, the learned counsel for the applicant, and also heard M.S.M. Chaudhary, the learned counsel appearing for the respond number 3. By the order dated 12/9/2022, the applicant was directed to take fresh steps into respond number 1 in posted post and as usual process. But from the notice note dated 2/9/2025, it is seen that the services steps are not yet taken to the respond number 1 and in that view, the petition applicant is hereby asked to take immediate steps on respond number 1 and 2 to register AD and as usual process. PCR PCR has already been received. After puja,
Lordship, Lok Adalat, I think, is on 13th, Lordship.
if you we can proceed. If you want to place it before.
It can be referred, Lordship, because the award is against respond number 3. It is on for enhancement, Lordship.
It's okay. Sorry, further considering the submission feedback and also for both sides. The matter for the local which to be held on 13th of September 2020. The Office of the Registry as well as the High Court Legal Services Authority will take the necessary steps. We'll try this.
In the meantime, I shall also take steps, Lordship.
Must oblige them.
Well, oblige.
May it please your lordship, LCR was called for and respondent number 1 and 2 appeared.
We are for respond number 1 and 2.
Respond 1 and
1 and
4 respond,
LCR we have already received. How many respondents otherwise?
4 lordship.
4 respondents. So on 25, then there was an order. Shall take steps for respond number 3 and 4. So have you taken steps and?
That I could not go to the text.
No, notice was issued on 5/11/24 year.
To whom? 3 and
To
4.
respondent 3 and 4
3 and
by
4, yes.
both ways.
Thereafter, there's no such note from the registry also in regards to the return of those things. But yes, it seems that on 5/11/2024, the steps was taken.
Lordship.
So you want to, if awaiting the service from 2000, let's say last 1 year, you may not serve your purpose.
Lordship.
So you can most probably should take fresh steps on 3 and 4.
Lordship.
Otherwise, so till now, there is no such note regarding the any service.
Service of notice.
Service of notice on respond number 3 and 4. So 1 and 2 have already appeared.
Lordship. So we will take a fresh steps upon 3 and 4.
Yes, 3 and
LC already received your lordship.
LC has already been received.
Lordship.
Heard Mr. P. Borodi, and also for the petitioner, and also heard Miss
TJ Sahewat.
Yeah?
TJ Sahewat.
TJ Sahewat, the appearing appearing, learned counsel appearing for the response number 1 and 2. From the office note dated 5/11/2024, it seems that the steps were taken for the response number 3 and 4. But there is no further note in regards to the service of notice on response number 3. In view of this, the petitioner is hereby asked to take fresh steps on the response number 3 and 4 to register it as a process. Scan copy of TCR has already been received. This is the matter accordingly after push application.
Lordship.
You take steps within 2-3 days.
Lordship. But you can that many fixed, Lordship.
You want any date?
Lordship.
After push.
After puja vacation. 15,
16.
oblige your Lordship.
May I please? Yes. My lord, I have filed an affidavit, my lord, in respect of service of notice upon respondent number 6, my lord. Wherein I have taken the service upon respondent number 6. Or Dosti service, rotated this by the registry of this court. So in this respondent number 6, my lord.
Six is the who is 6? Service cooperative society.
Yes,
or-
yes, my lord. The Kashipur Cooperative Society Limited.
It's Kashipur Cooperative Society.
Yes.
And you are representing
1 to 4, Lordship.
1 to
5.
1 to
5.
5.
They have entered appearance, my lord, for in behalf of respondent number 1 to 5, my lord.
5 is PWD department. Also, there is a separate standing council.
I mean, earlier occasion 5 appeared. or-
Yes. So notice upon all the respondent, my lord, complete. Matter may come up for hearing.
Okay, Purva.
Take notice.
Five, I don't know. 5, so definitely he is not going to represent 5, I think.
Maybe I may take notice, Lordship, but
You can take, you
I'm-
can.
Lordship,
If you want to represent, then it's okay.
Lordship.
Mr. T.U.
Well, you Laskar.
Mr. T.U. does still done it. Council for the applicant. And also heard. Mr. T.R. Gogoi, dependent government advocate appearing for the response number 1 to 4. However, it is submitted by Mr. Gogoi that he may take instructions in regards to whether for representing the response number 5. So it is a separate department. Further, it is submitted by Mr. Laskar that in pursuant to the order dated 18/6/2025, he has already taken steps to the response number 6 to Dusty Mode, and affidavit has also been filed in regards to service of notice to Dusty. It's here actually. Right. We have received it this year also.
LCF. Yes, mother.
This year has already been received. You wanted to, in admission column, we are final hearing for final hearing. Please see matter accordingly for final hearing. As on a date to be fixed by the registry after puja.
Of like. This is an appeal against the interim maintenance order passed by the London District Judge Law. Earlier, when the matter was listed before court, although they have represented by the other side, none was present. That is why the matter is fixed today. And it appears that Mr. Sarkar is appealing for the respondent. In fact, one aspect of the matter, I have the instruction that in the maintenance amount which has been paid to the respondent, they must discontinue it. Well, I am facing the difficulty to that effect, Malad. This is for the enhancement, but the existing amount is also stopped by the respondent, Malad. I'm a
No,
poor lady.
you are against the order of enhancement.
Enhancement.
Lordship,
So
on
was there
behalf
any
of
why you stopped
respondent,
payment?
Lordship, on behalf of respondent, they have filed Okalat Nama, will file affidavit. In the meantime, Lordship, the appellant is also a working woman. She's getting about 15,000 salary. And for the daughter, the respondent father or husband is paying 22,000 per month. And for the appellant wife, the learned court below passed an order for monthly maintenance of rupees 15,000.
No, this is the enhanced amount or the earlier amount?
Yes,
No, which amount? This is enhanced amount or earlier amount?
earlier.
He is talking about
Then
earlier.
you have to
Malad.
come before the
The
court
issue before this honorable court is Malad,
for
we are
enhancement.
claiming for enhancement. The landed this is the order against we are for this honorable court. So let's just
No,
kindly
you
look
are
into it.
only against the order of enhancement.
Malad, in fact, Malad,
we have to
existing
raise
amounts
your-
also not stopped by the that is my instruction as
what
on
ground?
today. By your lordship.
You are Mr. D.K. Sharma,
UK Goswami.
UK Guswami. Mr. UK Guswami, the non-counsel for the appellant. And you are
Respondent SK Sarkar.
SK Sarkar appealing. for respondent. Submitted by Mr. Sarkar, counsel for the respondent, they have filed their bakarat. Today only. It needs some time for the instruction as well as for hearing of the matter. Next, right, in that context, Mr. Goswami, the learned counsel for the applicant, submitted that there was no such order on stay, and the present appeal has been filed as agreed to the order passed by the learned district judge on the prayer of announcement, but during the pendency of present appeal, the respondent had stopped payment of the earlier maintenance allowance, for which the appellant is suffering from financial cost. In view of this, Mr. Shakar is hereby asked to take proper instruction from his client and affidavit. You're going to file. And also will file the affidavit of the if any honor before the next date. You want any fixed date here?
No, date may be fixed so that before vacation, Malad.
Vacation to not be possible.
There is a, Malad, in view of this situation, Malad, we are facing that they stopped their payment. That is why, otherwise I would not have.
Don't know because from the 22nd of September, there will be the motion day will be declared motion day that week only. So
Prior to that.
So be possible. 19.
Highly obliged, Malad.
All right.
Make decision, Lordship. Lordship, this case I mentioned and brought it, Lordship. What happened, Lordship? On 27/8/2025, the case was admitted. Admitted, Lordship. And on that day, the stay petition was, they submitted that they'll file objection to the stay petition. So notices were issued, Lordship, by that order. Then what they did, Lordship, on the next date, Lordship, on 28/8/25, they moved a petition before the tribunal, Lordship, and the tribunal has issued a writ for closure of the office itself. So, Lordship, we have mentioned it, we need a stay, Lordship. And the appeal, our appeal is that, Lordship, the mother was the owner of the vehicle, father filed the claim petition, and the deceased was the son. Lordship, as per Sarla Verma, only the mother can file a claim petition. Here, the mother is the owner. How the father and the son are third party to her, Lordship? That is the legal point involved in the case. So we need a full stay in this case, Lordship. And they said they will file objection and then they move their Lordship.
We did not say that. Lordship, you can see the order. There's nowhere mentioned that we file an objection.
Then, Lordship, if they are not filing any objection, Lordship will give us full stay. That is my humble prayer, Lordship. Because this is a case where that law point has to be decided, and it is already decided in Sarla Verma, Pranay Sethi, I have Sadanand Mukhi, all these judgments I have, Lordship. Where it is, and Bombay High Court judgment is also there, Lordship. I have that also.
Now hearing there.
He is respondent number 1.
Yes.
And apart from that, how many respondents?
2 more. Mother is the respondent number 2, and 3 is the driver. 2 is same family.
2 is my Lordship wife. 2 is the driver of the owner of the offending vehicle. I, being the father, was the claimant, Lordship. Lordship, Lanet Fair is emphasizing on the point, that law point, whether I can be Lordship claimant or not. That issue Lordship will decide during the hearing of the appeal, Lordship. And this plea they have not taken during the trial. Specifically has been taken, Lordship.
Law point, Lordship. We have taken,
But
I'll
they
show,
did not-
if now he's submitting both ways. He's
But
saying
Lordship-
that it will be decided in the hearing,
Yes,
final
Lordship.
hearing.
Yes.
And then again, he's submitting something that we did not take up, Lordship.
Yes, Lordship.
Here, Lordship, today I want a stay, Lordship. So my humble prayer is that Lordship will stay the
Yes, Lordship can stay, but Lordship, that 50% amount should be paid.
where is that?
No.
25,000, that is the
That is
statutory
stated
requirement.
for filing an appeal.
Yes.
Lordship, if my learned friend allows me to submit, I will submit. Otherwise, I will not. Because I am not allowed to submit, Lordship.
So you keep it.
Yes, Lordship. Because in this case, Lordship, what happened? I have lost my bachelor, Lordship, son, Lordship.
Lordship, are we doing the final hearing?
No,
That- I
Lordship.
have to be clear about
I
that.
have to be submit on these 2 aspects. I have to submit. Otherwise, my learned friend can submit. I will sit, Lordship.
No,
Lordship, what happened,
no,
Lordship?
just a second, sir. Mr. MS Mujumdar is submitting on the fact that that there are some law points involved.
Yes.
On that basis, it is submitted as, otherwise we have seen that these cases of suppose enhancement, suppose these other payment, these are other claim matters and all these things where the law points are involved, as well as we can dispose of the matter subject to 50% of the awarded amount.
Yes,
Whatever. There's been some. But here they have raised the issue of, in fact, some law points are there.
Yes.
That is why their submission is there, that has to be stayed. Order.
That Lordship will hear those law points at the time of hearing the appeal. Today, learned friend is on Lordship stay application. Stay application, what is the normal course, Lordship?
Normal.
I have lost my son in 2021, my only son. I have one daughter also, but Lordship, he was an earning member, Lordship. Now, Lordship, what is the difficulty in Lordship paying 50%? Otherwise, I have not got a single penny till now, Lordship. That is my question, Lordship. There is no difficulty. Lordship can stay, but subject to payment of 50%, Lordship. That is the normal, usual Lordship course. That law point, Lordship can hear during appeal. And that law point also, they never asked before the learned tribunal, Lordship. If Lordship, going by the version, the mother cannot be the claimant, then the father also cannot be the claimant, then who will be the claimant, Lordship? In this case, will I be rendered remedialess, Lordship? I have lost my son, Lordship.
Yes.
Admitted fact, Lordship. That Lordship will decide during hearing of the appeal, Lordship. Lordship, may kindly see page number, Lordship.
And who are the 2 and 3?
2 is Lordship, my wife, and 3 is Lordship, cousin of the deceased. So everything happened within the family.
Then there are some law points are involved, and what the appellant says that if there is a stay of 50% is there, they're claiming they're challenging the entire claim, in fact.
Yes, yes.
So in that case, there may be, I don't know, there may be some legal issues and all. So why don't you do one thing? If you can represent the respondent number 2 also, who is
That
your
will be,
wife?
Lordship, kind of conflict of interest, because during trial, she was my opposite party. I was the claimant. She was the OP number 1. During
that is
trial,
there,
opposite party. So there is some difficulty maybe.
So 2 and 3, what is the office do? Is there any service?
No, we could not take, because in the meantime, all these things happened, Lordship. And then
Why they moved to the tribunal? Which
That
we are part of
execution
the-
proceeding was pending. And now, Lordship,
for
because
execution only you moved there.
yes,
Yes.
and because now
Here
there is no
it's
stay.
pending here, and since there was no stay, Lordship, the court has issued a writ that the office will be locked, Lordship. How can that be, Lordship? Locked.
Because there is no-
He is submitting,
there is
he
no stay.
himself is submitting my case, Lordship. The respondent number 2 is the wife, Lordship. So will the respondent number 1 be third party, Lordship? He's saying conflict of interest. That is very correct, Lordship. Can the respondent number, the owner of the vehicle, vis-a-vis the claimant and the deceased, are third party, Lordship? They are not. They are from the same family. And Sarla Verma at paragraph 32, Lordship, very clear. Though even if the deceased is survived by parents and siblings, only the mother would be considered to be a dependent and 50% would be treated as. But the mother cannot be, because she is the owner of the vehicle. In every case, it is not that they will get compensation, Lordship. Sadanand Mukhi is there, where the son was driving, no compensation.
Lordship, what I am praying that Lordship may kindly very well stay the proceeding, Lordship, stay the execution, Lordship, but subject to payment, Lordship. Till now, I have not got a single penny.
Let him show any law, Lordship, where.
No, Lordship, we are not on appeal, Lordship. We are not on appeal, Lordship.
Lordship, no, in the stay,
we are not on
Lordship.
appeal.
We are on the stay, Lordship.
No,
Let them show that Sarla Verma and Pranay Sethi has
That,
been
Lordship-
overruled by any other judgment,
No, that-
Lordship. I'll agree to that. It is
Lordship,
not.
may kindly see
So
para.
I didn't get it. What?
And even if we deposit, Lordship, they cannot withdraw without a petition.
What petition?
I don't know. You are the counsel. Why you are asking me? You are the counsel. You know what
You have
petition.
said what petition I have to withdraw with petition.
মই এতিয়া অপোজিট পাৰ্টিকো এডভাইস কৰিব লাগিব
আপুনি ক'লে না petition.
পিটিশন নিদিয়াকে সেইটো মই সাবমিট আই এম মেকিং আ সাবমিশন বিফোৰ দ্য কোৰ্ট
এইটো মই এপ্লিকেশ্যন দিব লাগে, এইটো বেলেগ কথা। Different.
You know, it's fine.
And that is the usual course, Lordship. Even if Lordship directs me to deposit 50%, withdrawal may not be allowed. They have to file. That is the usual course. They have to file a petition for withdrawal, Lordship.
No, Lordship,
That is the way,
Lordship
Lordship.
may grant liberty to withdraw on being identified.
No, no.
That is
Lordship.
the order.
No,
That is the order,
where
Lordship.
where is
Main
the order?
purpose of filing this appeal may be first.
Yes, it will be infructuous. My appeal. Whole appeal will be infructuous.
In all the cases, Lordship, 50% is directed to be deposited. And on me
There are
identified.
some cases where it may not be, may
Yes.
not be a
But
proper
Lordship
time
can
for
speak-
withdrawal. And that's what I'm saying.
Yes.
So that's why once, what do one thing, Simoti Bonita Moran is your wife.
Lordship,
Yes.
And this is other one driver is the cousin.
that's the cousin of the deceased. My
And
nephew.
is there any order of, have you placed the order of the tribunal?
No, Lordship, we just, because I was in Niger last week, so I just mentioned it so that it comes today. We have not yet, but then what the tribunal, I have the order, Lordship. Both sides are represented. The JD has not submitted because the court felt, Lordship, submitted any order from the Honorable High Court which can show that this proceeding has been stayed by the Honorable High Court. Under the above circumstances, this court finds it justified to ask the JD to pay the decretal amount positively within, because this is the second order, already writ order is different, Lordship. Within 15 days, issue writ of payment accordingly. DH shall take step within 7 days, Lordship. This is the order. Just because there is no stay. As soon as stay is given by Lordship, this will be.
That is why, Lordship,
Stop.
there is no stay, the execution proceeded, Lordship. There is no bar, Lordship. Mere filing is not an automatic stay.
Next day itself, Lordship.
Maybe-
Here they
maybe.
appear and they say ki they will take, they will file their objection.
No, it is
On
not on the-
date 8,
it is not
Lordship,
on the record.
the order is passed. The
It is not on the, not in the order, Lordship. I did not press for any, Lordship, filing any objection. What are you filing
The
the,
order is, order is not there. Obviously, order is not there.
in
for
stay,
filing.
because what objection I will file, Lordship? That is the normal course of Lordship, 50% and that stay is Lordship allowed.
That is
At
not.
least
so,
Lordship, Lordship may kindly even now stay, subject to payment of 50%, Lordship. That is my humble submission. And
But
the-
if suppose there is no prayer for, there is no withdrawal is there, then in that case, we have to file a separate petition for withdrawal.
that
Money,
Lordship-
if there is no current, because they have issued the raised the point itself. So
But
there are
the-
some announcement question is there, other questions are there where 50% can be, the order of 50% can be there and it can be withdrawn also. There no, cannot be, may not be barred
Lordship, but-
because 50%. But here
Lordship-
in this case, the issue is raised by the Mozumdar is there is a bit different because
In-
there are own mother, father and son are involved.
Yes, Lordship.
So that's why I'm saying 50% can be there, but may not be withdrawal. Or we can do one thing, if matter may be otherwise decided also, but the question is that a stay will be there or not, because you have already approached the tribunal with a
That
application.
proceeding was pending earlier, since earlier, Lordship. After the award is passed. In the meantime,
Proceeding is
Lordship,
pending meaning execution.
execution. Now it is in the final stage because there is no stay.
They moved the next day
Yes.
itself, Lordship. 28. And here they took time.
No, we did not take time. Lordship, may kindly see the order.
It is not a question of order. I
Notice
was present there, Lordship.
notice was issued to all the respondent, Lordship.
Otherwise, I would have taken the stay that day itself.
No, Lordship, no.
Yes. I
National
would
Court
have
was not inclined to grant stay, Lordship.
There's no order of any prayer made by Hassan. In fact,
Yes, Lordship.
Mr. Hassan, the learned counsel party has prepared and accepted
Yes.
notice on behalf of no formal
Late month.
notice is required. That
Yes,
much only
yes,
is there.
that is true, Lordship. But
Notice was
he-
issued to all the respondents. Where
Please.
is the question of any stay, Lordship? I did not pray for
Today we
filing
are
any.
praying for stay, Lordship, because we are in that difficult
And Lordship,
situation
may
here.
kindly see-
In a case where there is law point, it is decided by the apex court that only the mother can file. So how can the father file
Lordship,
that?
may
And how
kindly
can the
see for a
court?
moment page number 12 of the IN. Page number 12, for a moment, Lordship. Page number 12, para 6, Lordship.
That will be hearing. Anyway, I'll also look.
Para 6. The opposite parties have contested the case by filing their written statement. In their written statements, over the opposite party numbers 1 and 1, 2 and 3. 3 was the insurance, Lordship. Have taken all the routine pleas, denied the case of the claimant and prayed for dismissal of the claim petition. And then, Lordship, para 8, Lordship, may kindly see. During the course of hearing, the claimant number 1 examined himself in support of his claim, whereas the OPs did not adduce evidence on their part. They did not adduce any evidence. They did not take any such plea, Lordship. I have lost. I have.
It is not that
Let
we
me
ask
complete,
for
Lordship.
dismissal.
Let me-
You are continuing, so you
Let me
will again and again say, I'll
No.
Lordship, are we doing the hearing today?
No, Lord, that is what.
So
that
he
is
is
what.
looking into the judgment, Lordship.
No, not judgment.
State,
I
Lordship.
am just pointing one thing. In 2021, unfortunately, I have lost my son. Admittedly, Lordship, there was a vehicular accident. Admittedly, I died, my son died due to that accident, Lordship. Learned tribunal, after hearing all the parties, after going through all the materials on record, granted this 10 lakh so-and-so amount in favor of the father of the deceased. They may take a law point. That will be decided during the hearing of the appeal. Lordship, if Lordship passes an order that they will deposit 50%, I will not be able to, Lordship, withdraw. Then what purpose it will serve, Lordship? Because the appeal may take time, 6 years.
Lordship, I'm ready to do the hearing next
But
week
for that,
itself.
Lordship, Lordship,
I'm
notice has
ready to do this case. In
notice
fact,
has to be
this
served.
next week I can.
Why my learned friend is not allow me to complete?
Continuing.
No, I am not continuing, Lordship.
You're
That
not
is what-
sitting.
No, that is what I am submitting. I have the right to submit, Lordship. Why am I
Let him
learned friend
submit
interfering, Lordship? What I am submitting is that the hearing may take 5-6 years. Notice has to go to respondent number 2, 3. I cannot take the notice on behalf of respondent number 2.
We can strike out 3, Lordship. We can strike out 3.
Why,
Because
Lordship?
this is on.
They have contested before
No,
trial.
3 it is on us. We can strike out 3. 1 and 2 are of the same family,
Then,
mother and
Lordship, let
father.
them strike out all the respondents. 1, 2, 3, all. Even I may be struck off.
That is some kind
She,
of a
Lordship,
ridiculous.
Lordship, he has appeared before tribunal, filed his WS, that Lordship cousin of the deceased. 2 being my wife, contested the claim. How can she, my learned friend, submit that he may be struck off?
That is our choice, Lordship.
That is why I am submitting that I may also may be struck off, Lordship. There will
That
no
is your
respondent.
choice. If you want to be
Yes,
struck
Lordship.
out, fine, Lordship.
Then there will be only appellant and then no respondent, Lordship. Lordship may decide. And if Lordship for a moment, Lordship, if observes that I may not be allowed to withdraw, then there is no purpose, Lordship. Already the executing court has, Lordship, issued writ. Executing court has, after going through the records, after hearing them, passed their order, Lordship. If the writ is Lordship, execute, I will get the whole amount, Lordship. And now, Lordship, that is why I am submitting, Lordship. Let them pay 50%, let the award be state, Lordship, and we may be given liberty to Lordship, withdraw the amount. That's all, Lordship. Why making things complicated, Lordship?
Yes, Muzumdar, anyone submit?
Lordship, my prayer will be that we need a stay, we need a full stay because of these judgments I'm submitting before Lordship, Sarla Verma and Pranay Sethi, Lordship. Only the mother can claim compensation when it is a bachelor. They are not denying that he was a bachelor. Lordship, I wanted a full stay, but Lordship, I am saying that 50% we can deposit, but no withdrawal at this time, Lordship. They file a petition, let there be hearing, and then there should be any direction of withdrawal, Lordship. That in usual course, that is usual course. Unusual course, in some cases, we take full stay, Lordship. It is not that we have to. Only requirement in MB Act is, Lordship, 25,000. That is the statutory amount which we have to deposit before filing of the EA. So in cases, Lordship, I have taken from Lordship full stay. I remember that. From other courts also, I have taken full stay. It is not unnatural. But since, okay, 50% we will deposit, but not withdrawal, Lordship. They have to file petition for withdrawal.
Then, Lordship, there will be no purpose, Lordship, because we have to file a petition.
File a petition for withdrawal. RMS, your stay is which one?
But
IA 2.
IA 2226 of 25. Lordship.
IA 225. This next, right, is submitted by Ms. Muzumdar. The petition for stay is to be disposed of, and she submitted that there are some law points on which the appeal has been filed, and basically states on the point that the father is the claimant here in this case, wherein the mother is the owner of the vehicle, wherein and the they lost their son admittedly in the said accident. However, it is submitted that they are ready to pay 50% of the awarded amount subject to stay of the further execution of the order dated, execution of the order dated
2/3/2020.
2024 passed by learned additional member number 2, MSCT, Tinsukia, Assam, in MSc case number 47 of the next para, Mr. Hassan, the learned counsel for the respondent number 1's raised objection and submitted that in that unfortunate incident, both the mother and he had lost his own son, and being the father, he has the every right to claim compensation for the death of their son. Accordingly, he submitted that a stay may be there, subject to payment of 50% of the awarded amount. However, the respondent number 1 may be given the liberty to withdraw the same. Next. Considering the submission made the counsel for the both sides, and also considering the fact that some law points are involved in the arrest of in the present case, the further the execution of order, judgment, and award dated so and so, passed by learned member MSCT so and so, into yes so and so. We state subject to payment of 50% of the awarded amount. However, at present, the liberty to withdraw the same is not given to the respondent number 1. It may be decided on the subsequent date on filing of appropriate application by the respondent. You can do one thing,
Deposit
Mr.
before the registry,
Yes,
lordship, my
before the registry. So, within 6 weeks.
6 weeks. lordship.
Within 6 weeks. We'll do one thing, Mr. Hassan. I can
Lordship.
also submit your problem. Now we can file your a petition for withdrawal on and that day itself, because we have not received the case record.
No,
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 it has not been.
it was asked.
Main to Likibo. Main to Likibo, respond number 1 had already appeared. Issue notice to respond number 2 and 3.
Lordship 3, we want to strike out. We do not
Already
want to
notice has
delay.
been- notice in the issue 2 and 3 also.
Lordship 3, we do not want to delay the matter, Lordship. So 3, I'm praying today that 3 may be strike out. I'll take notice on 2, Lordship, in the main appeal. Because he is not necessary, it is on quantum only.
Deliberation is submitted by Ms. Muzumdar that if the respondent number 3 may not be a necessary party in this case, and accordingly, read for striking out the name of the striking out the name of the respondent number 3 from the cause title of the memo. Considering the submission made by Ms. Muzumdar, the name of the respondent number 3 is hereby deleted, striking out at the risk of the act. Further, they will take steps for the respondent number 2. In the meantime, the registry will also take a necessary step in calling the TCR. Registry matter will deposit up within 6 weeks.
Yes.
Deposition will be 6 weeks and will list a matter. Maybe immediately you can take a date also immediately after vacation, so that if you receive the TCR, not only your petition, we can hear the entire matter.
Very fine,
That may be
very
can,
fine,
that may
Lordship.
can be done.
Yes.
And it will help the cut short the delay also, and in the meantime, as the respondent number 2 is your wife, you may make a thing that she may appear in the next day.
Lordship.
Not,
Yes,
not
Lordship.
to you, but to someone. But
Notice has already gone, I think, last day.
No,
Yeah.
because these
Not-
things happen,
not
Lordship,
yet,
we
not yet,
could not
yet,
take.
That may be at a date of after vacation. Registry will do the needful in calling the case record. 20. 28 will do, or it will be 28?
Wait.
28. If we receive the case record, then we'll
Yes, Lordship, that will be
28 of October.
28, Lordship.
Yes.
Highly obliged, Lordship.
Obliged.
Yes.
May I beg your lordship, my lord? This is a application, my lord, filed against the impine order stated, my lord, 29/8/2025, my lord. Now, my lord, the background of the case, my lord, because this is petition in connection with
Order column, why it is in order column?
My
Why
lord,
it is in order column?
actually, it should have been come in the motion column, my lord, as I understood, my lord, because on the other day when it is came up, my lord.
I paid
my
for
lord,
time, my lord, because I did not receive the copy because I
Copy that.
appeared in the case. And I received the copy that I fixed today. So your lordship may take it up as a motion.
Last order 3/9/2025, there was
Yes.
an,
Yes, my lord, because we appeared on that day. That is why, my
but
lord.
there was an undertaking, I think.
My lord,
It order speaks that Mr. Sahewala has given an undertaking. that
yes,
till
for
Monday,
till today, my lord.
and no execution proceeding shall
Yeah,
be
that
started. So
My
now
lord. So
what?
your
will
lordship
be-
may take it up as a motion, my lord. As a motion today.
No, is okay, but how many respond? You responded.
My lord, I am the main, yes, I am the main. Lord, actually, the decree has been become by this honorable court, my lord, in the second appeal. Now, my lord, they wanted to open, my lord.
I don't want to open, my lord. I do not like to, my lord, challenge that decree also, my lord. The thing is that, my lord, we have a
I shall
land
place, my lord.
in the fourth schedule land. Only the our prayer is that, my lord, the land which in our possession, which is the owner by virtue of the gift, that should be identified. Let them execute that decree, my lord. I have no objection at all, my lord. Let them do that, my lord. Because I am occupying that land by virtue of a gift, my lord. That is why
In that
some
case,
hearing is
do you
required.
want to submit any written?
My lord?
In written, do you want to submit anything?
Yes, I shall submit, my lord, because there is no merit at all, my lord. This is liable to be dismissed, my lord. Yeah,
Okay, then
execution is-
you can submit on merit, but the question is that the stay of execution will be on what? Because
No,
last.
stay, my lord, that stay should not be granted, my lord. That is why, my lord, I shall submit on merit. Because they wanted to go virtually behind the decree, my lord. Virtually,
I am not going behind
my
the
lord.
decree, my lord.
Because,
Then why the prayer for stay was there? On the last occasion, there was the stay. but
my lord,
then no
yes,
execution. Why?
because tomorrow is fixed for filing of the, my lord, return, my lord, regarding the cost of the police force, my lord, which is required. So that is why, my lord, I undertook to till today, my lord, that we shall not do it. Here, my lord, they wanted to call for some records, my lord, whether that ingredients are there or not, my lord, you lost to see,
Why not?
my lord.
But suppose if the execution is, the order decree is already executed, where there is any, will be any problem or no?
Problem will be done because, my lord, my land, what I said, my lord, there, whatever the decree vis-a-vis the schedule 4 land is concerned, my lord, there is a finding that we have a landed property there. But the thing is that, my lord, that landed property which I have acquired by virtue of this gift, my lord, my prayer is that, my lord, let them, my lord, make a proper survey of that land, my lord. Well, if I am occupying their land, fine. But if the, because if a lordship look into the decree will say,
No,
my lord, I am just.
no, I am on the point that if suppose the decree is executed, in that case.
My land, my property will go, my lord. That is the
but
whole
there is
problem.
no prayer for any. Now what to do is stay was till today only.
Yes, my
As-
lord.
as the
My
last one.
simple prayer is that, my lord, before, my lord, bulldozing my house, I am using that one. My lord, let them identify the my land, find out my land, because this schedule for loan.
Why they will find out?
My lord,
and
everything
decide
has
the
been
order?
decided by the
No.
school court in the second appeal, my lord. I shall place, my lord.
My lord,
Everything
there,
has been decided by
because
school.
beyond
In
the.
second appeal, is there any order on?
Yes,
because,
that
my
is
lord,
the next, my
stay-
lord,
stay-
page 87.
Because, my lord, beyond the
second appeal,
decretal amount, because the decretal land, that is the, my lord, more land in the particular particular schedule 4, my lord. So that is to be identified. Because of that, total land belongs to schedule 4. How much belongs to them, and the land belongs to me, which I am occupying, my lord.
My lord,
That is it.
your lordships will see the two applications, my lord, whether these are maintainable at all, my lord. On that order 13, rule 10.
That is why I call for the, my lord, record of the.
I say that these are not maintainable at all, my lord. The learned trial court has considered these applications and dismissed, rejected these applications. two applications.
No, what
Well,
they are-
these were already considered by the High Court, my lord. Your lordship should see.
I am not on that, my lord. I am not on High Court decided on the substantial question. I am not on the substantial. I am not on the decree also, my lord. That is my straight and clear submit. What I said, my lord, beyond their decretal land.
They are up to decree only.
Yes.
My lord, they are decree, vis-a-vis their decretal land.
Yes.
What I am submitting, my lord, beyond the decretal land, there are other land also in the
So,
particular.
RSA, in the RS also the order was there, but the question is that now the decree tell then,
Yes,
there or there before the, after the decree tell then, or the
yes,
decree.
yes.
My lord,
So you are saying one hand that you are not against the decree and also
But
your land has
what
to
I
be
am saying is
where it
that,
will
no,
be
no,
done.
what I am saying, my lord, that beyond the decretal land, we have also the landed property in Schedule 4. They say.
You enjoy your property.
yes,
Yeah.
my lord. How?
That is why some, my lord, what I said, my lord, let them, my lord, bifurcate the land, then let them identify my land, their land from my land. Because
Why
the, in
why
Schedule,
they will
no, my lord, because in
Understand, my
Schedule
lord.
4, they say,
If your lordship will see, my lord, page 102 of the High Court judgment, our my lord, declaring the suit for recovery of khas portion of the land included in Schedule 3 and 4.
yes.
So Schedule 3 and 4, I shall get Schedule 3 and 4, not more than that, my lord. How
Right.
they are affected, my lord, I do not understand.
No, why this, my lord? Lordship will kindly see. First judge, I will take my lord to the judge. Then lordship, I have to go through the entire judgment, my lord, to make to understand the case, my lord. Because in a
long hearing cannot be there. It is an
yes,
order
my lord,
but-
I am submitting.
Prior to that, my lord, your lordships may see the applications at page 110, whether these are maintainable, my lord, whether ingredients of order 13, rule 10, 2 is satisfied, my lord. These are not satisfied, my lord, at all, my lord.
Let them
Why
say by-
didn't necessary, my lord? I do not know. My lord, because 13, 10 is whether applicable to execution proceeding also, that is also doubt. 141 says these are procedures are in respect of miscellaneous matters, it is maintainable.
It is
Yeah,
in execution also.
Any case, my lord,
So
even
this
if it
petition
is
was under order 13 rule 10 only.
10
2.
2. Now, your lordship will see, my lord, that whether 10 2 has been satisfied here. They have called for the records of title suit of 76, my lord, 62 of 71, my lord, and 335 of 81. I do not know, my lord, why this is necessary. Because this order 13 2, 13 10 2 says, my lord, if your lordship will see section 13, order 13 rule 10 2, my lord. I am giving the judgment also, my lord. Here is the quoted, my lord. Our High Court judgment. My lord, your losses may come to page 2, my lord.
Yes.
Order 13, rule 10, 2. 10, 2, your losses may see, my lord. Every application made under this rule, unless the court order directs, is supported by an affidavit showing how record is material to suit. How record is material to suit, in which application is made, and that the applicant cannot, without unreasonable delay or expense, obtain a duly authenticated copy of the record or of such portion thereof as the applicant requires, or the production of the originally necessary for the purpose of justice. These materials are necessary, my lord. This last paragraph your lordship may see. Subrule 2 of order 10, quoted above indicates that every application calling for record of any other proceeding from any other court be supported by affidavit. 1. That how the records were material to a suit in which application was made. That the applicant cannot, without unreasonable delay or expense, obtain a duly authenticated copy of the records for such portion thereof as the applicant requires, or that the production of the original record were necessary for the purpose of justice. But this is whether these materials are there in the applications. Your losses may see. It is totally absent, my lord. At page 110, first your losses may see they are calling for records of 2 suits, my lord. I do not understand why it is. The entire petition may be seen, my lord.
Lordship may come to page 104.
It's not a case at all, my lord, that the High Court will interfere here. Because court cannot go behind the decree, my lord, agree to. If it is beyond the Schedule 4, my lord, what's the difficulty, my lord? I do not understand. I am only executing Schedule 3 and 4.
What is your prayer in this case, basically?
My lord,
His prayer is basically.
there your losses will see two suits are called for. Record of title suit and record of title suit. My lord, two suits. I do not understand why this is necessary. These suits were disposed of long back, my lord. And why the original records are necessary, my lord? The rider is there in order 13 rule 2. That why it should not be dispensed with by filing the certified copy of the same.
Lordship will see kindly hope, say, page 104
But similar application is another application is there, same, but TP case is called for. I do not understand why it is another same petition, but similar type of petition.
Look for see. My lord, page 104, Lordship will see, that is their application. On the basis of that application, that order has been passed. Lordship will see.
For vacating this stay order.
Yes. It is after the second appeal was dismissed by this court, my lord. So when the process, when the my lord court people went to our land, my lord, then we only came to know that this order has been passed. They're going to take the possession of the land. In view of that, my lord, we filed this petition because not recorded. If your lordship look into 104, no record was traceable from the honorable in the honorable court, my lord. So therefore, my lord, we paid for, my lord, that calling of the record. There is no bar. What the court can, my lord, for the ends of justice, court can do that, my lord. What is the bar? And lordship will kindly see then pays, my lord.
You are praying to call for the record before the executing court.
Before from executing court should call for the record of this court to the, so that they can go through. Because we don't have the record. We don't have the record of the, my lord, the partition case, which by virtue of the earlier decree in the
You were not the party to the case?
My forefather was the party to the case. Now they have died. We are only legal representative, my lord.
No, it's
Third
okay.
generation.
But you were the party initially.
Yes,
the original suit, you were the party, I think.
My lord, no, my.
No, you are not the party.
No.
Predecessors were party.
No, your predecessors means you are.
My predecessor, my was not a party, my lord. The lordship kindly see page 114. That
Your
required.
predecessors may be party. Predecessors means you are the party. That means we are not the party.
Huh? Yes, yes,
Your
ma'am.
predecessors
But
were the
I am the third generation, my lord, because I was a minor at that point of time.
What to say? You are
That is the
minor.
problem. Huh? I am now, my lord, I am the minor at that point of my life. Then this where
Yes, we are not going to hear the entire case. What to do? Yeah, stay was there up to today.
My lord, that is my undertaking, my lord. That is my undertaking.
That's right.
That is your undertaking.
Yes.
Yes, I can understand. So if you want to place the matter on stay and all, then we have to hear the matter.
Yes, my lord.
But if in that case, if suppose execution is there, then his case may become infructuous. In that case, what to do? Till instead of listing, can it be any?
My lord, there is a case since 71. I have filed it, my
71
lord.
years, I can
My
understand.
lord, and your losses seen, my
And
lord.
if stay operates, then it
It may
can
fix
be
the
reduced.
expedience of order 13 rule 10(2) has
It's
not been
here.
satisfied.
I have seen.
Not been satisfied, my lord.
Well, I have.
And more,
Why he need the two records in?
my lord, I do not understand, my lord, why it is necessary. My lord, because everything is there, my lord. Schedule 3 and 4, my lord, if you also see, my lord.
You were to execute the decree on schedule 3 and 4.
3 and 4, my lord. And my lord, I do not understand, my lord, why he is apprehending that in the executing civil 4, my lord, we shall acquire their land, my lord. My lord, schedule 4 and 3 are described, my lord, fully in the decree.
So
Yes,
you know
my lord, lordship,
what's
and
the
see the
description of
boundaries
the
of
lordship
agreement.
plan.
Your lordship may observe, my lord, that the decree.
No,
will
no,
be-
no, you are, Mr.
My lord-
you know the description of schedule 3 and 4.
Yes, lordship, I
Then
kindly
what is
see,
the harm?
my land is also there in the schedule 3 and 4, lordship kindly. see.
Now, what do you want to do? This court will pass the order, what kind of order? Because second appeal has already been disposed of. I
Yes,
think. Then
my lord, what
what
I,
is the remedy?
no, my lord, what I, let the execution court call for the record of these two documents, my lord, let them again verify, why that? 3, 4, what?
Again, when,
Yes.
again,
Yes.
case has to be.
Because to the, in the hands of justice, my lord, that is because I will be then, my lord, homeless. If it is not properly identify my suit land from their decreted land, my lord. So that is why I am called for the record, because of, my lord, page
Identification was there,
104,
I think.
my lord.
Identification was there, I think. Your land is
Yes,
separate.
yes.
land.
No,
My lord, in the second.
But
that
just
is
first
what-
tell me
my
whether
lord,
she-
that is why I call for the, my lord, record of this case, my lord.
No, whether schedule 3 and 4 land includes your land also.
Yes, my lord. My lordship will pays 117 then. Lordship will kindly see.
So before exiting court, have you brought
Yes,
all these things?
my
Before the
lord.
executing court,
Lord, that is why, my lord, I said, lordship can kindly see page 118.
you only filed a petition under order 13 rule 10.
My lord, to
Whether
call for-
any other petition was there under 100 or 97, whatever, under the execution under 21. Order 21, was there any or
They
order
have filed a
97,
petition under section 47 also.
47,
That I have not filed, my lord. That I have not filed.
Then
I have not filed.
how executing court will operate now? How it will
I
pass
have
order?
not filed.
My lord, I shall, so my lord, they have filed it.
I have not
47
filed.
file.
Yes.
I have not filed, my lord. I am not there.
I don't know, my
You
lord.
have not filed?
No, my lord, my name is not, I am not filed, my lord.
47 is also there, my lord.
Yes, 47 dated 151 is there.
Yes.
Yes, I am not there, my lord. Your lordship see the petition of
You are not there?
Shobhadeep Roy. I am not there. I am not there. I have not filed that petition, my lord. My simple case is there, record with PP, because PP Patta case is required, my lord, because they are, according to them, some demarcation has been made, this and that was made. But physical position, they cannot declare. First decree was that they cannot be given any position. The trial court did not give them any position because the land is occupying by the, under our occupation, my lord. A symbolic position was there. Then, my lord, they filed another suit for declaration of the actual physical possession, my lord. That also declared by the trial court. They then go for the appellate court. Appellate court gave them the actual possession. So their problem is start from there. I am not here there. I am concerned with my 1 bigger what cut of land or is a gifted property of mine, which is gifted by my forefather. I am concerned with that only, my lord. Now, if your lordship see the decree, my lordship will find.
One thing then, we cannot spend much time there here.
My lord,
Can it be until next date, can it be there?
my lord, page 103, you also will see, my lord, the High Court judgment, page 102. The schedule 3 and 4, exclusively, my lord, dealt with. They have argued fully, my lord.
Lordship, who is the leader of the text?
Para 25. Para 25. my lord. I do not understand, my lord, why, how these two petitions are maintainable at all.
No, why not?
When the ingredients of order 13, 10 is not there, my lord.
I will just explain.
They could have produced a certified copy of the, my lord, record.
It is not available, but that is why I call for lordship 104 order. That is their application on the basis of which the court is coming to a finding. My lord, page 104. Lordship may kindly see again. And that is my translated copy of the my lord, decree passed in a trial. So lordship will find, we are concerned with 3 and 4. Lordship will find schedule 4, dark number 357, 358, total land in so and so, so and so. Not remaining field of the dark. So this schedule 4 comprise of the our dark also. Land of our dog also, my lord. But our land is situated. Huh?
So you are agreed to the order of this 13 to rejection of the petition.
Yes, my lord. Let them call for the what is the my lord, no heaven will fall, my lord, because if you just to prevent the injustice, my lord.
Justice, since 71, my lord, I am fighting. My
And
lord,
if I am
your lordship
dispossessed,
see,
my lord, if I am dispossessed,
for
then there will be more injustice to me.
54 years. today 54 years, my lord. And now also, my lord, as said, my lord, taking of a decree is easy, but executing is very difficult. And
That
that
we
is
know.
what happened here, my lord. So why your lordship will interfere, my lord, now? I do not understand, my lord. There are several judgments of the Supreme Court, my lord. I don't think, my lord, there is a case at all.
No, page 114, my lordship says.
In that case, we need a hearing. In fact,
Lordship, yes.
today both the parties have submitted to the list. I have not noted down it. Can it be? We'll fix a fixed date. Then till then there will be.
It may be fixed, my lord. There are lots of one. Tomorrow it may.
Tomorrow there is another problem. Our list is deferred. I think.
My lord?
This list, the cause list is deferred. I think, due to some reasons. It will be to hear you.
Thursday. Thursday হয়েছিল। না, Thursday থেকে আমরা অসুবিধা। Thursday, Saturday হইতে পারে না। Affidavit দিতে নেই,
You're saying day after tomorrow?
Tomorrow? Yeah.
Tomorrow, I don't know.
Day
There may
after.
be some from day after tomorrow.
Day after.
And what about your undertaking and all?
My lord, tomorrow nothing will happen, my lord, within 2 days, my lord.
Well, it may be continue, my lord, until my lord.
And has a motion, my lord.
Yes.
In motion column. By Mr. B.K. Still and senior advocate, Mr. Tiger. MSTJ Sahibala.
Oh, my lord, can it be fixed on Thursday to be hearing day? Then, my lord, it can be hard lordship of it. Thursday only, my lord. Only 11th. That will be. Because the motion day, my lord, my senior friend maybe, maybe also, that is a Thursday.
You are saying Thursday?
Thursday, my lord, that will be better. Hearing day, my lord can. Otherwise, motion day, there are many cases.
Thursday, 11/9/2025. And interim order, but interim order date 3/9/2022 will be operated till the next. List the matter accordingly on treatment. Okay, by listing it on 11/9, you can hear in the motion column itself, we are fixing it on motion column.
Lordship,
That the
lordship.
matter may be hard on.
Yes, hello.
We can hear the matter also.
Lordship, boss.
Up to 11/9.
Only, my lord, that may be continued till 11 month. Otherwise.
I verbally undertake, my lord. Your lordship
That
cannot
may be
record.
recorded.
I shall inform the party.
That may be recorded, lordship.
They will not take.
That may be verbally undertaken. How can I record?
My lord. Otherwise, that is on the other day also
11/9,
verbal submission was
11/9,
made,
yes.
my lord.
Okay.
On other day also verbal submission. On the basis of that, this honorable court recorded that they have given an undertaking, my lord. That undertaking may continue till 11. That's all.
If Mr. Sahaba further verbally submitted that he would take the undertaking that till next date of listing, there may not be any execution proceeding. There may not be any execution of the decree. 11/9.
Deeply obliged.
Obliged.
May I please, your lordship?
Yes.
Your lordship, this is an application filed by the claimant for withdrawal of the deposited amount deposited by the appellant insurance company.
Is there any?
Lordship, we don't have any objection, subject to the deposit of an indemnity bond, Lordship.
In the earlier order, there was no order for withdrawal.
No order.
I do think. Heard Mr. Devon, the learned counsel for the petition. Respond. and also her.
Appeal to I. Itu I.
You are MS Sakya or
M cycle.
M Sakya? The learned counsel for the respondent of the app. Next, this is an application for a direction to the registry to release the 50% of the award dated 25/9/2024 was deposited by the appellant in compliance of the order dated 18/1/2025 passed in IA Civil 37 of 2025 arising out of MSC appeal number 04 in favor of the appellant. It is submitted by Mr. Mondo that by the instant petition, the respondent claimant, you are the claimant also?
Claimant.
How many claimants are there? Only
One, your lord.
How many? 3.
No, your lordship, this is a disability case, injury.
Ocha, one. Okay. Claimant, then claimant paid for withdrawal of the 2% amount which has already been deposited by the appellant before the registry. Next, I must say that it also for the appellant submitted in this data, they have no objection subject to furnishing of a indemnity. In view of this, the registry is hereby, the petition is allowed. Accordingly, the registry is hereby directed to release the 50% of the deposited amount.
No, your lordship. 50% of the awarded amount.
Oh, sorry,
Deposited
50%.
amount will be
Sorry.
half.
Okay, 50% of the awarded amount which has already been deposited by the appellant after due and proper verification, subject to furnishing a indemnity. With the above observation, the I stand.
Obliged. The main appeal, your lord.
Yes, in main appeal, what is the case now?
I am for respondent number 1
Yes.
and my learned friend is for
Main appeal.
respondent number 2.
So now service is completed or how many? You are
I'm respondent number.
Mondal is appealing for the
One.
number 1.
Only
You are-
driver left. Only driver left.
Driver left.
Driver left.
Is there any office note? Or is it office note? Process server notice there are 3 could not be served as addressee could not be found out of and kept in fact. So it could not be addressee could not. You can
We'll ascertain the correct
assert
address.
in the present and permanent address.
Yes, got
Hard MSF second for the applicant. And also for Mr. E. Monton, the learned counsel appearing for the respondent number 1 and MS. Mr. Ajay Burwa appearing for the respondent number 2. From the office note, it reveals that the service on the respondent number 3 is still awaited. And still awaited, no, sorry, return answer with a report that the addressee could not be found. In that context, MS yes, the counsel for the appellant submitted that if she will verify the present and proper address of the respondent number 2 in this context. MS,
Your
the
lordship,
appellant is hereby directed to take fresh steps on the respondent number 3. It is present and proper address. Record was already called for.
Lordship, if the record is called for, then
Record be called for. The TCR be called for. TC matter accordingly after the.
oblige.
You take, I have not submitted anything that you will furnish the proper address before you find out the present and proper address.
Yes, got
Then you can take steps. I have already passed it.
Yes, got oblige.
Oblige.
May it please your lordship. My lord, I am the appellant pro forma defendant number 4, the counter claimant. On 37/25, it was already admitted in the IA, my lord, because there was no execution case. Notice was issued. Now the execution case has been filed. Now, my lord, the executing court wants a stay order. Otherwise, this was the order filed, order passed by the executing court. So I am before your lordship. Till the returnable date, let the other side come, my lord. The execution case may be stayed. Your lordship may turn in the, because the trial court has decreed that both of us pro forma defendant number 4 and the plaintiff both have a right title interest over the land.
So by that present interlocutory petition, what was your prayer?
Well, for stay of that, because the execution case has been filed and I have given that order. Madam.
So it is 4-9 was fixed for
Now it has
hearing.
come on 21/9.
21-9.
So, my lord, by that time, puja vacation will come, my lord. If they don't turn up, then it will be havoc. So your lordship may stay there till a returnable date, let them come and they will object if required. Because, my lord, as per, my lord, the judgment of the Supreme Court, what I find, my lord, if a appeal is admitted and civil consequences are there, normal phenomenon is to stay that proceeding. Want to take a copy?
But why the order was not passed in initial?
Because if
order
no
did
execution, no execution case number was produced, nothing, so notice was issued.
So till now, you have not taken any steps for respondent.
I have taken steps, notice is yet to be served in. Because in the meantime, they are proceeding with the executing case. This is, we have taken steps, these are the copies, man.
No, in the main appeal, most probably you have taken steps, but here in the I, you have not
Well, we
taken
have taken, we have given, I've given. I is Krishna.
note in I. I Mr. P.K. Roy Chaudhary, the learned counsel for the applicant. Expert is submitted by Mr. Chaudhary that they have already taken steps for the respondents, but the respondent had already filed the title execution case, which is numbered as TX title execution number 30 of 2025, 44th of Learned Civil Judge Junior Division at Borpeta, and the case was fixed for 4-9 for hearing, and subsequently it is fixed on 21-9 of 2025. If further submitted, if there is any the decree is already executed, the purpose of filing the appeal will become will be frustrated or in frustration. To that context, he also relied on a decision of the Honorable Supreme Court reported in 1982, 3 SCC 484, Victor Liquidivo, Mul Chanda, so and so, wherein also it has been observed that during dependency of any appeal or order which have some serious civil consequences connected to the appeal must be stayed. Must be stayed. It is submitted by Mr. Chaudhary that as in the earlier petition, it could not provide the title execution number as it not registered. But that title execution case has already been already registered, and the order has accordingly passed on 20/08/2025, and hence a stay of the execution, decree of the execution is required to, no, sorry, and hence the it is a requirement of stay of the operation of the implement judgment and dated, order dated 21/12/2024, and a decree dated 2/1. Next, considering the submission made by and considering the other aspects, is let the execution case number 30 of the 2025 be stayed till next date of this thing. This matter accordingly. Okay, there will be a stay.
Obliged, move.
Online already. 41 or log of.
There are two revision petitions. Now it is 3:30. Whether, my lord,
These two are for hearing, na?
yes, madam. It may require some time. There are two.
Definitely time will, definitely time will require, but for last so many dates.
I'm not at. You are also not at.
No, but one question is there here, one issue is there. If suppose we cannot remain kept as a partner in this matter because of some problem, because tomorrow also we cannot fix.
Madam.
There are some changes in the bench because of some emergency, because
Then, that date-
2 or 3 bench most probably will be on vacation, I mean, on leave. That is, there some special arrangement may be there.
Madam.
So in that case, if we kept it part-heard, or if we kept it tomorrow also, it may not be possible for
My lord.
to hear the matter. In that case, it may again delay.
Madam.
Otherwise, it's only 3:30. But will you be able to finish by this?
Possibly not.
Definitely my learned brother will take.
He will continue, he will take actually more than 2 hours.
No, no, no. I will not
I
take.
know, I
I
know
will
you.
take, I will not half an hour.
He will take only 10-15 minutes. How much will take? The food I said, that much only you tell her.
Because when I'm the loser, so I need to, my lord, argue the matter in detail. Because decree was passed in his favor on the ground of bona fide requirement. And so far the defaulter is
But though
concerned,
decree was passed, most probably he could not enjoy the fruit
Yes,
of the decree.
that
till
is-
date. That is the, when the decree was passed?
decree was passed in the year 2024.
No,
Yes.
appellate court, appellate court
Because
of
judgment was
title suit of the 2016.
16. My lord, this is second round of, my lord, litigation. Initially, my lord, I approached this court by filing a revision petition. Then judgment was set aside. Remanded back the matter to redecide the
And
matter.
initial judgment was passed in the year 2017
No, 17.
by the trial court.
Hmm.
So thereafter, he preferred an appeal, being a tenant. So that appeal was dismissed.
So till now you could not evict him.
No, against that
still
he
there.
preferred a revision.
And revision was allowed.
And
Setting aside the
revision not allowed,
Setting aside the
subject,
judgment.
setting aside.
Yes, yes.
So only to decide the question of
No,
the
no.
due date. All right, setting aside.
Setting.
All right, due date is there.
And
So accordingly, matter went back to the appellate court. Appellate court again decided
In your favor.
in my favor.
only on the ground of bona fide requirement. Defaulter is decided in my favor.
The defaulter is deciding that he is, the
not a
appellate court says he is not defaulter. So that is why I filed
But
the
bona fide requirement was
only
correct.
bona fide requirement, and I filed another revision. That is item number. That is CRP number 100,
Yes,
item number 41,
yes, that was filed by
That-
you.
filed by me, challenging the issue that is decided against me. That is a bona fide, that is a defaulter issue.
Defaulter.
Oh, that has, you challenged that.
I have challenged it.
And Mr. Purkastra has challenged.
He
the
challenged the
others.
bona fide requirement.
But one issue decided against me, one issue decided against him.
Actually, my lord, it requires some time. And my lord, I can understand court says it is the choice of the landlord. He is the best man, he is the mustard. But I refer to some decision, my lord. This is not the parameter. Parameter is otherwise. If you want to, my lord, grant a decree on the ground of bona fide requirement, then there are some parameters that.
Earlier, the entire this act was inclined towards this tenant. But now concept have, to some extent, it has been
Yes,
changed.
My lord, court has referred one decision, that is of 2001, and I have referred number of decisions after 2001. Supreme Court says, my lord, this is not a straight cut formula, that he is a master and it is his choice, but his approach must be honest, fair, bona fide. These are the three basic parameters.
Okay, then we can list the matter otherwise.
After vacation.
Not before. Before
vacation, I
vacation.
may be possible. Because I am on the way to, my lord, outside the state for treatment.
Not in Arunachal.
Not in Arunachal. Arunachal nowadays, my lord, I used to
And all right, this meta may be listed as the top of the list.
Yes, yes.
That can be.
After vacation. You choose
Even
it.
if suppose after vacation also, do you want any fixed date?
Top of the list.
Yes, yes.
No, fixed date.
Fixed date, yes.
You want
Fixed date.
fixed date.
Today I prepared the case, man. I was in a position to argue the matter, but due to paucity of time, my lord.
Council for the coordination, council part, Mr. AK protest for the respondent. He to tapo ulta for a same order. And due to paucity of time, the matter will not be heard. This the matter on that certain 1610. List the matter on 1610 and
16.
registry is hereby asked to list the matter on hearing list at the top of the hearing.
Top of the list.
I'm on the interim order.
In which you are enjoying the
I'm
interim order.
enjoying
Yes.
order.
CRP 41.
Lordship, 41.
CRP 41 of the interim.
41.
41.
Interim be continued.
I'm grateful. Indeed, don't mind. Keep it.
अब क्या चल रहा है?
देखो तो ये क्या है? जी